I may be allowed to mention. Because I have suspicion. Because I have been instructed.
Yes.
Sorry.
You are appearing for?
For the associations, my lord.
For the Bombay Bar Association.
All the three associations.
You are appearing for Bombay Bar
For
Association,
Bombay Bar,
Advocates Association of Western India,
and the incorporated law.
and the incorporated law.
There was somebody for the High Court.
So I appear for the state of Maharashtra.
Now, what has happened is that the reason we thought we should monitor it is that there was a judgment of the High Court.
That is so.
Now, pursuant to that, lands have been allotted to the High Court at Bandra East. Now, possession has still not been handed over to the High Court. There are two aspects which really are of concern to us. One, that possession has still not been handed over to the High Court, and many of those lands are still in occupation of staff colonies. Now, the state government has to start the process of getting that vacant and hand over possession to the High Court so that construction can begin. The second aspect which, Mr. Solicitor, we thought we should request your presence and really your good offices for the Union of India is that today's building of the High Court now is over 150 years old.
It's a heritage,
It's
more than a heritage.
Now, I don't think any structural audit has been carried out of the building since 2017. The High Court is in dire need of accommodation to shift some of its offices because we will have to have a structural audit in terms of safety conducted of that building. And there are other adjoining buildings which are available. So until the High Court's own structure comes up at Bandra, if the Government of India can perhaps, for instance, there is one MTNL building. There is another building which is of the Central Telegraph Office, just across the road from the High Court. Now, Telegraph, of course, has become obsolete. So the CTO building is available. If the Government of India can, sort of... yes, exactly. Parade. So, if the Government of India can intervene, facilitate with the Government of Maharashtra so that in the interim period, that area can be given to the High Court, which is critical for its functioning. Because otherwise what is happening is that the whole building is carrying the weight of the books, the furniture, everything. And about a year ago, there was an incident in the library where a whole slab fell. And fortunately, none of the lawyers were there present in the library at that particular time. It happened in the night.
I may, Lord.
Air India building would also be available now. I think it's taken over by Government of Maharashtra.
Lord, I may, Lord, inform your lordships about something which will not be possibly within your lordship's knowledge. Lord, few responsible individuals, responsible members of the bar met me in a personal friendly capacity for this problem, Lord, say about 20 days or so, Lord, before. And we discussed the problem regarding the shifting of the High Court. There is no denial that it needs to be shifted. In their presence, I called the Honorable Deputy Chief Minister, Lord, of Maharashtra, that this is the problem. He said, I am aware of the problem. Ask your friends to come to me at any time because there are some internal issues, but I will not say problems. Some wants a land, some may have preference.
No, but now that is finalized.
It is now finalized. It has to be...
Yes, sir. May I, if your lordship permits, just give a chronology.
Yes, sir, only a minute. Yes. So he said...
The AG wants to say something.
No, I'm just completing. Yes. So he said, come and meet us, whatever is to be done will be done. And he said, that's my promise. We are with the bar.
Only one thing now, let's have clarity so that, there's no uncertainty about it. This land at Bandra East has been allotted to the High Court.
Correct.
There was some, there just happened to be a conversation in the court, I believe, in regard to some lands at Goregaon. Goregaon is not convenient. Those lands are earmarked for the Maharashtra National Law University. Bandra is by all circumstances more convenient for lawyers, litigants from different parts of the city. So let's now first and foremost bury this notion that some other lands apart from Bandra are going to be allotted.
We are given to understand. Yeah. I'm not aware of even geography of Bombay.
So, Mr. Advocate General, what do you have to say, Dr. Saraf?
Lords, may I just clarify, Lords? Just to give your Lordship's background, Lords. Lords, I respect that the court has taken cognizance of the matter. And Lords, we are here to assist the court in every which way. Lords, I am myself a member of the bar. But I wish that the bar at least would have inquired from the court or at least from me as to what are the steps taken. Just giving your Lordship a few chronology. Because this plot of land has been identified after a great deal of discussion with the High Court. High Court had identified and approved this plot of land on 3rd of October 22, Milords. It was known that there are government colonies on this plot of land and that this is a part of an integrated development of that area. Immediately thereafter, Milords, in March of 23, a GR was issued by the government. And Milords, after that, several steps have been taken to immediately, Milords, vacate that plot of land and to try and see as early as possible the land can be handed over to the High Court. Milords, thereafter, on the last occasion when the court took up the PIL, which the Bombay High Court is seized of, an entire plan of action along with a plan was given to the High Court, pointing out in what stages the land will be allotted. Milords, giving your lordship a few figures, a total land of around 30 acres, 30.16 acres has been identified for the High Court, out of which 8.5 hectares is for the High Court buildings and other areas.
8.5?
8.5 hectares, Milords.
And 30.16 is acres.
Acres, yes, Milords.
Right.
And around 3.63 hectares are for the lawyers' chambers.
Yes.
Because I've been a part of this journey as a part of the Bombay Bar Association for several years, so I'm familiar with this. The bars were called upon to give their requirements and all, and this land was identified. Because in the plan, which has been given to the Honorable Bombay High Court on the last occasion, the state has identified that by December of 24, 9.64 acres will be vacated.
How much?
9.64 acres.
Yes.
By March of 25, 13.73 acres will be vacated, and handed over. Then, there in the periphery of the plot, which I can demonstrate from with a plan on the next occasion, there are certain government colonies. They will not come in the way of commencement of the construction. The main central area will be vacated, and the construction can start. And in the periphery, whichever government colonies are there, the phase-wise vacating of those is also given to the High Court. Because the thing is, this is a whole integrated development. The construction for shifting these government offices...
December 2024 is too long. Why should the government... I mean, you allotted the land. You allotted the land in March 23. Now we are talking about December 24.
May I just clarify why?
Take steps to get these lands vacated and handed over immediately to the High Court.
Plus, the difficulty is when the land was also allotted, it was known that there are existing government colonies on that plot of land. The building is being constructed.
There's not like a builder being told that, well, there are existing government colonies. You are giving it to the High Court.
No, I understand, but I need to shift those.
Given the land now, this is the duty of the government to hand it over immediately. Can't be December 2024. By December 2024, construction must begin. Because that's one thing which we'd like to ask the High Court about what steps is the High Court taking to at least draw plans, the tendering.
Because I'll also tell you, Lordship, just 2 or 3 more facts. Just 2 or 3 more facts. Because the High Court appointed a subcommittee of the.
And Dr. Saraf, those staff colonies which are in the occupation of people there in the colonies, the government must provide alternate accommodation to them and hand these lands over.
Yes, because the buildings for shifting them are at an advanced stage of construction. The OC for one building has already been received. And the other buildings, this was always told to the High Court even when this land was identified. And so far as the Goregaon land is concerned, that was just a casual suggestion made by the petitioner in that petition. And they said that now the Goregaon land can be reconsidered. It was just a casual observation saying just let us know whatever is there. There is nothing that the court has asked us to shift the land from Bandra to Goregaon. This land is identified.
That's over. Well, let's not even think of now Goregaon. We have identified now the government has already made an allotment of the land at Bandra.
Yes, that is what it is.
Bandra. But Dr. Saraf, we would like the government now to be more proactive. You can't now wait
until
December 2024.
But please bear with me only to this extent that I need to have some place to shift these existing staff. Their buildings is a part of an integrated development of the whole area, and this was known even when we identified the land. So give us that much leeway. We are doing every step possible to ensure that this land can be vacated as expeditiously as possible. I'll surely put it to the government to further expedite it to make the timeline as short as possible. so that the construction can commence.
At the highest, you can take the period of the monsoon, and monsoon normally ends in the first week of September. By September, you must give lands to the High Court, because otherwise, and second, simultaneously, there has to be an effort to start the other process, because this is all government land. Now, in the meantime, why wait for the actual handing over of physical possession to start the drawings, the plans, the tendering process,
and
design?
The drawings are, I think, ready.
Almost ready.
Plus, may I also update the court on that? The High Court appointed a subcommittee, including of Public Works Department officials, to visit various High Courts. They have visited just recently the Lucknow bench, the Jharkhand court, the Jodhpur bench of the Rajasthan High Court, and the Delhi Arbitration Center. And they have visited with the court officials all these benches to have a look as to how those buildings have been developed. And immediately a report has been given to the High Court. The High Court now is in the process of initiating the entire process of preparation of plans.
But that shouldn't come in the way of handing over the land to the High Court. I mean, you can go and visit the High Courts for the design.
Secondly, you should also understand ground realities. You can't evict the person's overnight.
I understand, Milord. I'm not saying it's adversarial.
Plus, the thing is, we did not
It's not adversarial. Let's all work together. Is all.
Your main concern was that the government is not moving at a right speed.
That's it.
And then about the party Goregaon thing.
It's not that the government told the government that it can be located tomorrow. It was known, and please give us that much leeway to make sure that our staff can be shifted in a building which is under construction. We'll try and expedite it as much as possible. Please take it from us. The government is equally concerned and equally interested in making sure that the best possible infrastructure can be provided to the High Court.
And Dr. Saraf, the third aspect now about giving the High Court not alternative, but additional premises in the vicinity of the High Court. Because the construction may take 2 to 3 years. Because it's not something which is not a small building which is being constructed. So in the meantime, I think we have to ensure that a structural audit of the present building is carried out immediately before the monsoon, so that we are aware of what the safety concerns of the High Court premises are.
We'll get it.
Second, we would like the government of Maharashtra and the government of India to sit together and tell us, say by next, we will keep it, say next Friday. And which is the building which they are identifying? Let there be a common meeting between the Chief Secretary to the government of Maharashtra, a representative of the Union government, and the Chief Justice in the course of this week, so that alternative building is identified, and then we are told on the next day that this is the building which we are providing for the High Court to shift its staff so as to reduce the pressure on the existing building.
As an interim.
We are happy to do that. Whatever is required from our side.
Fire in Mantralaya. The Mantralaya building was not put in use, so they had made alternate accommodation for Mantralaya offices in Kuprej and Kappared, some areas in Nariman Point. There are 3 or 4 buildings belonging to MTNL. One is just across the...
There is no resistance or reluctance. It has to be putting our heads together and fire. That shall be done.
We'll do it.
On the alternative building, please make a statement before us by next Friday. We'll keep it on the 17th, which is the last day before we close, on what has been identified, so that then we will pass an order that, well, this has been identified. Other issues such as the financials is between the two governments, the central government and the state government. It's a small issue.
I didn't speak on that day to this union government, but state government at a personal level did tell me, the deputy CM, that finance is not a constraint, land is not a constraint, the will is not a constraint. We can sit together and finalize the plan of action. We are full in favor of a new High Court building. There was unreserved statement and in presence of some responsible members of the bar.
All right. So we'll pass a short order then. The assumption of we pass that short order. The assumption of the jurisdiction under article, the assumption of the suo motu jurisdiction by this court has been premised on the extreme urgency of the extreme urgency in regard to the accommodation needs, of the needs for proper accommodation for the High Court of Judicature at Bombay. Full stop. The existing building is well over 150, nearly 150 years old. Full stop. The government of Maharashtra, on 3 October 2022, the High Court approved the proposal of the government of Maharashtra to allot land admeasuring for the allot at Bandra. Should we say Bandra East, Dr. Saraf, or Bandra?
East. You are mute. East. You are mute.
Bandra East or Bandra? What should he say?
Bandra East, Your Lordship.
Bandra East, Mumbai. Full stop. The Advocate General, Dr. Birendra Saraf, informs the court that even at that stage, it was known that the lands are in the occupation of government colonies, housing the staff of the state. Full stop. A government resolution was issued in March 2023. Full stop. Accordingly, steps are being taken to obtain to hand over vacant possession to the High Court. Full stop. The Advocate General has stated that a total area of 30.16 acres has been allotted for the purposes of constructing the building of the High Court and other pertinent facilities, including chambers for lawyers. Full stop. This comprises an area of 8.5 hectares for the High Court building and 6.36 hectares for the chambers for lawyers. Full stop. It has been envisaged by the state government that by December 2024, an area measuring 9.64 acres would be vacated from the staff colonies and handed over to the High Court, while an area of 13.75 acres would be handed over by March 2025. Full stop. It has been stated that there are staff colonies on the periphery of the land which has been allotted to the High Court, but that this would not come in the way of the progress in the construction for the High Court. Full stop. There are three aspects of the matter which would warrant immediate attention. The first pertains to expeditious steps being taken for handing over vacant possession of the site to the High Court. Full stop. We are conscious of the humanitarian facets involved, since since staff colonies exist on the land which is allotted to the High Court, and the residents and the occupants would have to be relocated elsewhere. Full stop. Conscious as we are of these aspects, we are of the considered view that the state government must now act with all alacrity and substantially expedite the original the allocation, the handing over of vacant possession to the High Court, so that construction can commence at the earliest. The second aspect relates to the need of the High Court for the allotment of additional space in the vicinity of the present building, which is situated at Fort Mumbai. Full stop. The existing building is bearing the brunt of the offices, so of several offices, as well as the judges, as well as the courtrooms, bar facilities, and chambers for judges. Full stop. The need for the High Court for the allotment of additional space is pressing. Full stop. We have requested Mr. Tushar Mehta, the learned Solicitor General, to intervene in the matter so that his good offices can be utilized to bring about an early resolution in consultation both with the union government and the state government. Full stop. There are buildings in the vicinity which may be utilized for that purpose, for the purpose of the High Court. And the financials in that regard would have to be worked out between the union government and the state government entirely at their end. Full stop. I have therefore requested that in the course of the ensuing week, a meeting be convened with the Chief Justice with the learned Chief Justice of the High Court of Judicature at Bombay, and the building committee which will be attended by the Chief Secretary of the Government of Maharashtra the Learned Advocate General, the Learned Advocate General, and sufficiently senior officers and officers at a sufficiently senior level of the union government.
Yes.
Full stop. We also request the Learned Solicitor General to join in the meeting online. Full stop.
Whichever, even physically, if I need to, I'll go.
Online. If
It will be a miscellaneous week.
it will be a miscellaneous week. So now actually,
We can't afford not to have you here.
by the way, there's a little.
I
I must tell you one. Judges so hard over the term that we do not have enough matters for miscellaneous week now.
Yes.
Yes, sir.
This is a very different situation. This anyway, more of that later. The third aspect, we would expect that this court would be apprised on the next date of listing of the decision which has been taken in that regard. Full stop. The third aspect pertains to the commencement of the process for preparing the drawings and designs for the new buildings and appurtenant facilities of the High Court. Full stop. The Advocate General has informed the court that a subcommittee was constituted by the High Court, which has visited several High Court buildings in the country, including the buildings at Lucknow, Jharkhand, Rajasthan, and Delhi. Full stop. We have the considered view that the High Court should in consultation with the CPWD, proceed immediately to a stage where the drawings can be finalized so that the tendering process can then be initiated. The antecedent work need not await the actual handing over of the possession of the building to the High Court. Full stop. Having flagged the above three issues, we now direct that the proceedings be listed before this court on 17 May 2024 at 10:30 a.m. when the court can be apprised of the progress which has been made on all three aspects noted above.
Plus, only one clarification that there are also some encroachments on
in order to ensure in order to ensure the structural safety of the existing building of the High Court, the PWD shall immediately have a structural audit of the existing premises carried out so that this court can be apprised of these safety and other related aspects of the existing building. Full stop. The court may be apprised on the next date of listing of the steps which have been taken in that regard.
Please.
So
Sorry, I just wanted to clarify one fact.
They say Public Works Department, Maharashtra. Anything else that we need to say?
May I just clarify one fact?
Mr. Advocate General, you and the Learned Solicitor, you just both need to push the requisite authorities.
When the question,
We'll get it done. Only one clarification may I
My
place on
Lord
record.
Justice Gawai is a witness, my Lord, the way I work.
Mr. Advocate General,
Quite
yes.
appreciate and please.
Sorry.
Notes,
When we have said that there are government colonies, there are also some encroachments and steps are also being taken for removal of glass, as a matter of fact.
While editing the order, I'll mention the encroachment. Sorry. Mr. Thakkar, of course, you are represented by Mr. Nikhil Sakadande, but would you anything that you and Mr. Venkatesh the learned senior counsels would like to mention to us, which we have missed?
Well, for the time being, this is sufficient, but we fear that the structural audit report will not be very favorable.
You fear what, Mr. Thakkar?
The structural audit report will not be very favorable. We may be required to vacate the High Court premises very soon.
No, I don't think so, because when I was the chairman of the building committee, we had carried out a structural audit. And that time, whatever lacunas were pointed out, those were corrected. So,
Thereafter, we are informed that in last monsoon,
indicate that we have to reduce the burden on the building, then the non-essential amenities can be moved out. That's what we will have to do.
but there are a lot of
like we have shifted
leakages.
the library
Lot
from
of leakages.
the
during
library is
monsoon.
on the ground floor.
ground floors.
There are a lot of leakages during monsoon.
So that obviously, I mean, we are not coming. And one more thing that we'll also say, the pendency of these proceedings, the assumption of jurisdiction by this court shall not in any manner operate as a restraint on the High Court, both on its judicial side and administrative side, taking necessary steps in implementation of the decisions which have already been taken for the shifting of the building to Bandra East.
My lords, may I just suggest if someone can from ASI can also join the meeting, since it's a heritage structure. Archaeological Survey of India.
Let the Chief Justice can also. The Chief Justice will be at liberty to nominate any other members to attend the meeting.
Or say, PWD will.
We already have an heritage architecture.
Yes, my lords. Yes.
No work can be carried out without a permission.
Yes.
Anything else, Mr. Sakadande? Anything else that you want to say, Mr. Dond? Anything else? Since both of you are on the line,
He's on mute.
Unmute करना पड़ेगा.
Don't you are mute. You will have to unmute.
No, they'll have to unmute.
Yes, my lord, I am extremely grateful, my lord, for your lordship's intervention. My lord, your lordships have jump-started the whole process.
Dr. Saraf, please do let the Honorable Chief Justice know that the idea of these proceedings is not to either take over the authority of the justice or any of the judges in the building committee. It's just because, we thought that being here, there are different levels of government involved, particularly in relation to the allotment of alternate lands, the additional land. We can use our good officers to expedite that process so that everybody is safe and protected in the High Court.
Plus, we welcome your Lordship's initiative, and plus, please take it that from the state of Maharashtra, there will be every possible cooperation that is required, and plus, we have been
we'll continue. During the lunch hour, we request you to just walk across to the Honorable Chief Justice and please convey our feelings that the idea is not to take over the good work which is being done by Justice Upadhyay, but just to sort of expedite things, that's all.
Yes. Certainly, Millard. We will also accompany the Learned Advocate General to do that.
Thank you. So we'll meet on 17th now for this matter in the morning.
Please, Lordship.
I'm okay.
to mention one.
Just send an email. Send me an email, yes.
My lords, I have bench.
Don't worry, then I'll take cognizance.
I will take 30 seconds. Lords, this matter concerns the Jeevan Jyot building in Mumbai, which is in a dilapidated condition, my lords. There are orders of the squad for
All in the email. Just say it. in the
10,
email.
my lords. So 3 judges required, my lords. That's the difficulty. And your lordships were.
I've already allocated a 3-judge bench yesterday, he says. Last night I allocated a 3-judge bench.
Deeply obliged.
Email now. Then I'll deal with it, yes.
Lord, item 10, there were 2 matters which were mentioned yesterday. Your lordships are directed. Lord, I'm sorry, my lord. With reference to item number 10, there were 2 matters which were mentioned yesterday. Your lordships are directed those matters to be taken up along with item number 10
no
today.
problem. All matters will, because the point is the same.
My lord, we had given a letter to the registrar also.
Yeah, no difficulty. Everything will be listed.
But
Good
it has not been shown in the list today.
Makes no difference. You are here.
All right.
Lordship,
It will be taken up.
Lordship, I may be allowed to.
Get proofs were not there, therefore they couldn't list it under the.
Your Lordship, I may be allowed to.
Yes, sir.
Your Lordship, I may be allowed to mention one matter, Your Lordship. You know, it is the original suit of 96, Your Lordship. No, Your Lordship, it was moved, Your Lordship, but it was.
Send me an email. I'll pass necessary administrative directions.
Please, Your Lordship.
Sorry, tax we will take after this. The moment West Bengal gets over, we will take a start the tax. Yes.
May I place it on behalf of the state? The SLP 9586.
Yes.
For myself and Mr. Colbler, we are appearing for the state of West Bengal.
It will be 10.1.
9586.
Yeah.
So broadly, Lord, in this group of matters, there are 2 separate aspects was involved. The segregation part is one was.
Mr. Paul, you can have a seat. Why are you standing? Why do you have a...
My back requires me to stand longer than sitting. That's what I was saying. That's what I was advised, so I avoid sitting for too long. Sorry. That's the reason I stand better.
So far as
some mobilization exercises for the back. That's a professional hazard for judges and lawyers.
Yes.
So long as you keep your back mobilized, the lower back mobilized, by doing some stretches, that is very crucial.
Advice so
Just 10 to 15 minutes, but we all tend to neglect ourselves,
This can be debilitating.
Oh, it is completely.
And with some people, Lord, we have to sit for some time and stand for some time and have a standing table.
Even for conferences, that desk now helps a lot, my lords. Stand and do conferences.
Yes.
That's very helpful.
So you do that, is it?
I do that. I've started doing it. So it helps not sitting through the conferences myself.
It's better that lawyers start doing this from an early age, rather than wait for us to reach our age, and then it become difficult to resolve. So there are 2 aspects.
Yes.
As I said, the segregation aspect, whether the candidates who have been found to be tainted, or rather the tainted and untainted, can they be separated? Is there enough material on record to segregate them? And whether the defects found are so widespread that the whole must go, the whole selection process. That is one part. The second part, Lord, with which the state is concerned, because under the Act and the rules, there is a central commission which makes the selection, and there are boards, Lord, regional boards, which the board of secondary school, the board of higher secondary school, the board of madrasas, so who make appointments first. The state's statutory duty is limited to creation and sanction of posts and bearing the burden of salaries. So they do not come directly into the process of selection or appointments. Now, that is not to say, Lord, that the states overall are not responsible for the education in the state, but the various selection processes which are held from time to time are in the domain of the Central Commission and the boards. So I'm, my lord, confining my submission on behalf of the state to clause 8, which your lordships had stayed, my lord, for the time period. I'm not concerned with the segregation part. The commission's council and the other learned councils who are representing the candidates who are affected, they will be assisting your lordships on the question whether segregation is possible or not. They have the material to show. I'm only confining to clause 8 direction which has been issued and stayed by lordships.
Yes.
Incidentally, my lords, on 23rd of November 2022, Justice Gangopadhyay had for the first time by an interim order, interlocutory order, directed a CBI inquiry into the question of creation of supernumerary posts. That order is at page 506, at page 515. And in an SLP filed by the state, my lord, the Chief Justice was pleased to grant an interim order stating that, which is still pending, that is on 25th of November 2022, which is at page 518.
Yes.
That matter is still before the lordships. And one of the reasons, Lord, for this intervention by this court was that none of the writ petitions involved any challenge to the order of the state government creating supernumerary posts. That was never in challenge. The lordship turns to page 518 of volume 2.
Yes.
And the matter came up before Justice Gangopadhyay on account of the fact that the Selection Commission had moved a IA, which they call CAN 2 of 2022 in this matter, where they sought permission from the court for creation of this supernumerary posts. But it appears that inadvertently or whatever it be the motives, I do not want to go into that, but they mentioned to accommodate illegal appointments. The idea was that when the appointments are set aside by the court on account of these corruptions, etc., and there's long drawn litigation which is going on in that court and this court, so in the meantime, some supernumerary posts may be created so that those who are in the wait list, they could, regarding whom there is no issue as yet, so they could be accommodated. For example, my lord, in one case, this lady Soma, my lord, she had approached the High Court and the High Court itself directed. Her case was that some people who are lower down and not in the list have been appointed.
That is a medical case.
Medical case, so therefore that was appointed. Now, If you kindly see page 519, item 6.
Yes.
Lordships have extracted the order of the learned single judge from the High Court. It is thus submitted that if any other illegality concerning the appointment of Group D staff is identified, it is humbly proposed that apart from giving recommendations and appointment to genuine candidates as observed by this Honorable Court by its order dated so-and-so, supernumerary posts be also created to accommodate those whose appointments are subsequently found to be invalid. Such proposal will result in no loss of jobs and enable such appointees to have means of livelihood. However, in the event of such proposal being accepted, appropriate directions be given that such persons do not have seniority over those eligible for appointment. So while this order direction was being passed, the state in fact appeared and told the court that this is contrary to the state's order creating the post, because that was meant for waiting list, not for invalid appointments. That those who are declared illegal, they will again come back through supernumerary posts. That was not the intent, and we produced that order. But even after production, nobody challenged that order. Even that's what I'm showing his purpose is. Nobody even then amended the petition to challenge that order at all. And the Lordships have then wrote at page 509, paragraph 4, state this. In paragraph 9, page 520.
Yes.
So this petition is pending. So the question is identical whether the... Yes. So neither it was an issue, nor it was made an issue after production of the order. And it remained as such because my lords had stated. Now, the other thing is that with respect to these 6,000 to 861 posts which were created,
6,861.
Kindly turn to page 367 of volume 1. The proposals had come from the commission and the board to the state government saying that they have themselves detected a lot of cases of rank jumping and all that.
Yes.
So they themselves detected. So since they had detected, they recommended that from the wait list, that was their recommendation, which was accepted. And kindly see at page 367, having recorded the proposals at the bottom of the page 367. Now, therefore, in exercise of power conferred under Section 19 of the West Bengal School Service Commission Act 1997, the governor has been pleased to create 6861 supernumerary posts of teachers and non-teaching staffs as detailed at para so-and-so for absorbing the wait-listed candidates in the supernumerary posts so created as per approval of the state cabinet. And please turn overleaf. In exercise of the powers under Section 3.2 of the West Bengal Board of Secondary Education Appointment, Confirmation, Conduct and Discipline of Teachers and Non-Teaching Staff Rules 2018, the Governor is further pleased to direct that appointment letters to such waitlisted candidates should be issued in terms of recommendation of the West Bengal School Service Commission in strict compliance of the extant rules, subject to the outcome of pending litigations before the High Court of Calcutta. So there was no attempt to overreach the court.
Can we just go back to that order for a second?
Yes.
That's the page, Annexure 7, right? Page 367.
Yes.
Right. I was just trying to locate it up to now.
I'm so sorry. At the bottom of the page I was getting that. So I think PDF is different also.
398.
398. I'm so sorry. At the bottom of the page is now therefore in exercise of powers conferred under Section 19 of the West Bengal Service Commission Act, the Governor has been pleased to create 6861 supernumerary posts of teachers and non-teaching staff as detailed at para 4 for absorbing the waitlisted candidates in the supernumerary posts so created as per approval of the State Cabinet.
Yes.
And the next page, Vinod, 399, that's PDF 399. In exercise of powers under Section 3.2 of the West Bengal Board of Secondary Education Rules 2018, Governor is further pleased to direct that appointment letters to such waitlisted candidates should be issued in terms of recommendation of the West Bengal School Service Commission in strict compliance of the extant rules subject to the outcome pending litigations before the Honorable High Court at Calcutta. It was all subject to the High Court that if they are set aside, in that event they are to be accommodated. That was the spirit with which this order was issued, and keeping in mind the spirit, not barring Soma, nobody else was appointed at all. The posts remained vacant.
What was the occasion to accommodate 6,800 waitlisted candidates?
The objection really will be now this, that if the at present there's no question of appointment because once the whole selection process has been found to be vicious.
But why did the government create what is the
that was during the process. During the process when the selection list this judgment had not been delivered, in between the process, there were various inquiries being done, one by Justice Bag's committee, then by CBI, affidavits were filed. Commission itself was required to go into it, and they also filed affidavits showing how many rank jumpings, etc.
This selection related to which year?
The same selection was. That's 2016.
Right, and the government created posts in 2022.
They were creating because what happened in this case that all selection list was finalized in 2018. Then January 2019, all appointments had been done. Now this challenge itself was raised in the year 2021, that's after 2.5 years. So that's why in the process, because the records which are to be preserved for 1 year, they were weeded out. All this happened because after 2.5 years, therefore all this problem was arising. So, of course, the problem was of our own making, so we are not saying.
Suppose a candidate on a select list or the waiting list were to file a writ under 226, give me an appointment. The simple answer would be to such a petition that, well, what is your vested right? After 6 years, you can't even get appointed.
Yes.
Because the tenure of a wait list can never be that long.
Yes.
Now, this was 2016.
No, in fact, in
2022, the government creates 6,800 supernumerary posts.
So, in fact, 2019, it was already declared that this panel is dead. Now, because the writs are being filed in 2021, 2022.
Look, I only added one thing. Because the reports came that there are potential irregularities and the matter was pending in the High Court, the fear was that tomorrow if they are struck down, there will be a huge vacuum. It was in that background that a suggestion was made and a whole cabinet note after discussion was prepared that in case that were to happen, where would we go without 25 or whatever 10,000 who are struck down? So why not in the meantime take the waitlisted candidates against whom there is no allegation at all on a supernumerary post subject to outcome of the writ petitions which are pending. This was the suggestion.
Sure,
So the purport of my respectful submission is this, my lord, that it is one thing to say that these orders are illegal. Maybe because panel has expired long back, or the power doesn't exist, or that it was unnecessary. So therefore, the order is illegal and deserves to be set aside. And this part of the legality part is engaging the attention of the High Court in the writ petition which I just now pointed out.
250 of 2020.
Yes. 250-56, 25056. So the legality of that, and we are today, given this nature of the order, the question of legality doesn't really arise. It goes, if the selection goes entirely, that goes also. The wait list also goes, everything goes.
But that, Mr. Dwivedi, actually goes against you, because if the entire if the selection itself was under a challenge, then where was the occasion for the government to use the wait list in that same selection process then for creating supernumerary posts? It's aware of the fact that the selection is challenged.
It's like this.
Why would you create supernumerary posts?
Now, can you look at it this way? It was not expected at that stage that the entire selection will go. The way the proceedings were going, in between, there were some orders passed that 329 posts are appointees, they were invalidated. Then 800 were invalidated. So it was expected that some part of the tainted candidates will go, and therefore, Lord, there will be need to appoint from the wait list. That was according to the CBI affidavit, also 8,000.
Of how many candidates?
It's about 24,000 something. All I am trying to endeavor is to show that there is no malice behind, my lords. Malice in fact. Our expectations, on hindsight, one may say, or hindsight also say that one should have awaited, my lord, the final judgment of the division bench and then proceeded to do something. What I am today questioning is the direction for a CBI inquiry. I am not on the legality part.
That's the point, basically.
Basically, I'm saying that Lord, CBI inquiry can be directed only if even prima facie the High Court finds that there is some criminality. So we may have gone completely wrong. It may be illegal. But the fact that we did not appoint, and the order said that it is subject to the orders of the High Court, and even the application of the commission said, Lord, we are seeking approval of the High Court. High Court could have rejected that application, the matter would have ended. Assuming the High Court feels that the two are interconnected. Though we said that commission's application is contrary to our order, but yet, for the sake of contention, if I assume that the High Court said it is Binami application is on behalf of the government which is wanting to create, but we went to the court, the commission went to the court with an application permit. So court did not permit, the matter ended. It's not that we were trying to overreach and bring into the stream some people from the wait list.
On your application before the High Court
rejected, never passed any order. It's said that they started investigating, and that order has been stayed by your lordships. Justice Gangopadhyay's order, he said that it seems that this is not from the chairman of the commission, there are some higher persons. So, I mean, I don't want to go into that.
So you sought the approval of the High Court. High Court didn't grant that approval, and therefore no appointments were made at all.
That was an application by the Selection Commission.
Selection Commission.
Which traveled to the Supreme Court, and your lordships passed the stay order. Ours was an independent exercise as far as supernumerary posts are concerned, because these were from the waitlisted category.
Okay.
But so I'm going a step ahead and saying, Lord, even if the High Court...
Is there a finding of criminality by the High Court while referring...
Nothing. Can you see that there's no discussion at all?
All right. That's the point.
That's my humble submission, and I rely upon, Lord, this judgment of full Constitution Bench judgment of this court, 2010, Volume 3 SEC.
Yes. Page
571. State of West Bengal versus Committee for Protection of Democratic Rights.
Well settled.
Para 70 and 71. The last two paragraphs. I'll just read out. Lordship may not.
That you shouldn't pass it as a not.
And that this para 71, Your Lordships approved minor irrigation case 2002-5 SCC 521. This court had said that an order directing an inquiry by CBI should be passed only when the High Court, after considering the material on record, comes to a conclusion that such material does not disclose a prima facie case calling for an investigation by CBI or any other similar agency. We respectfully concur with these observations. And in this case, Lord, with respect, Lord, there is absolutely no finding, Lord, the prima facie of any criminality, nor can there be. First of all, Lord, there is no issue. Even when we produce the order in the Can 2 of Commission, still thereafter nobody amended the petition. Nobody is saying, Lord, that this order has been passed with a malice. Secondly, in both the cases, our order also says, Lord, subject to the orders of court and the application itself of the Commission, though little misconceived and erroneous, still it said ask for permission. So there was no case, that somebody is trying to bypass the whole judicial process, and investigations going on and appoint from the wait list. And thirdly, nobody in fact was appointed. So in fact, there could not have been any finding of criminality, nor there is.
Mr. Dwivedi, the CBI investigation had been directed to continue by our court itself.
That's right.
So there was a CBI investigation going on in regard to the criminality in the main
matter about those appointed.
Which would also include the waitlisted candidates.
Yes.
Now, if that was so, then is the High Court not really only in this direction of the High Court? Is it not in furtherance of what we have directed ourselves?
No, your lordship directed in continuance of CBI inquiry, which was already going on with respect to those who have been appointed, namely rank jumping, namely outside the sanction post, more than the sanction post, they were being appointed. Those who were where this OMR sheets was problem. So they were investigating the selection process.
Same selection process, right?
But nothing has been appointed. Nothing has happened. Where is the question of criminality if the government passes an order which remains on paper? So what can be an attempt to commit what crime, my lords?
All right, we'll
so that's the issue, my lord, which I am raising. And moreover, my lord, lordships have said apart from this judgment that there has to be compliance with natural justice. No pleading, no issues. Where is the hearing going on this aspect? Focusing on this aspect. Then the state should have been put this issue directly, not whether why should not that CBI inquiry be directed? Then all these arguments, Lord, we would have placed before the High Court, where High Court would have considered these questions, these aspects.
Thank you, Mr.
May I just add two submissions for your Lordship's kind
Yes.
consideration? My Lords, admittedly, it is a fact that a single judge of the Honorable High Court was seized of the cabinet note issue. This matter was neither argued, nor were we ever called upon before the DP, nor was the subject matter of the matter pending before the division bench, the cabinet note at all. But more importantly, please see, where does the impugned order go completely wrong? Kindly have para 265 on page 226 of the impugned order.
Para
265.
What page would that be? Do you have the
Page 226 of the paper.
257.
PDF 257.
Yes.
My Lord has that?
Yes.
The state government, therefore, has accepted that there were widespread illegalities in the selection process and that the number of persons who received appointments illegally could not be determined with exactitude. They had resolved to create supernumerary posts to accommodate illegal appointees. In other words, state has reserved to expend taxpayers' money to accord sanction to an employed secured dishonesty. There is no appointee as far as the waitlisted candidate is concerned. They completely mix it up with the earlier recommendation which your Lordship stayed of the SSC. This was a cabinet note prepared on waitlisted candidates. No one had been appointed. So there were no illegal appointees. Now read this, my lords, with para 355. Please read this with para 355 on page 277. PDF 308, my lords.
The issue of whether the reference should be made, this investigation should be made by the CBI or not.
I am instructed to say subject to correction. I am instructed to say this was never an issue before the division bench, never argued, never called upon to answer. It is pending before another judge. It's pending before the single judge in Calcutta High Court. Let's kindly have para 355 of the impugned order, page 277, and PDF 308.
Suggesting what would you want to us to see, Mr. Gaul?
Para 355 on page 277, PDF 308. What's happened?
Yes.
Investigation by CBI with regard to the creation of supernumerary posts is imperative to bring to light the nature and extent of the scam and persons that are involved therein. It is shocking that at the level of the cabinet of the state government, decision is taken to protect employment obtained fraudulently in a selection process conducted by the SSC for state-funded schools, knowing fully well that such appointments are obtained beyond panel and after expiry of the panel at the bare minimum. So the state cabinet, all departments, the entire memorandum which is prepared under the state rules. And I just showed to you, Lordship, there's a whole rule, there's a whole procedure, rules of business. The manual concern of the state government under which cabinet notes are prepared, the administrative department, legal department, finance department are all consulted. And then a cabinet note goes up to the cabinet. So you are today saying, firstly, you get it wrong, you talk about illegal appointees. These are waitlisted candidates. Secondly, you today want to include criminality. And look at the dangerous precedent it sets, that in every matter of these kinds, the entire cabinet, the whole process, everyone will be subjected to a CBI investigation. And most importantly, now see, my lords, in this background, paragraph 363, subclause 8, what is the direction given? The direction given is on page 363 at page 281, clause 8. Yes. CBI will undertake further investigations with regard to persons involved in the state government, approving creation of supernumerary posts to accommodate illegal appointees. If necessary, CBI will undertake custodial interrogation of such persons involved. So, my lords, today, as your lordships are well aware, with the entire West Bengal Secretariat Manual, Chapter 6, rules of business, officers involved, departments involved, everyone who prepared this, including the state cabinet, the Advocate General, everyone will be subjected to, because the legal department, the finance department, everyone is involved. The approval of the legal department was taken. Everyone will be investigated by the CBI and if required will be taken into custody. And please see 118, what were the issues framed by this court in this matter, my lords, because your lordships asked me a pertinent question. Was it my instructions were never argued, never raised, not the subject matter, but the issues are called out in para 118, PDF 191, para 118. Yes. The previous enumerated rival contentions have been related. The following issues for consideration. Does this division bench have jurisdiction to hear all the writ petitions and appeals listed before it? Are the writ petitions maintainable at the behest of unsuccessful candidate writ petitions subsequent to the expiry of the validity period of the panel? Can appointments be made subsequent to the expiry of the validity period of the panel? Is the certificate dated so-and-so valid and admissible in evidence? Should the OMR sheets available in the seized hard disk be uploaded in the server of SSC to compare with final list stored therein? Should any reliance be placed upon the data stored in the seized hard disk to terminate the services of any employee? Can the recommendation be withdrawn by SSC without hearing the appointee? Whether revocation of recommendations under Rule 17 by SSC is valid or not? To what relief or reliefs are the parties to the appeals and repetitions entitled to? My lords, with respect, apart from not being an issue, it's an extremely dangerous precedent that we are setting. What are we saying? That a court without an issue being raised, discussed, today orders a CBI inquiry if required with custodial interrogation, right going till the cabinet, with no proof, nothing, no suggestion of any criminality, and everyone gets roped in. Now, the whole cabinet process of decision making, my lords, in a parliamentary democracy, where do we go? Look at the far-reaching consequences of this direction which is being given. Apart from getting it completely wrong at the cost of reputation, talking about illegal appointees rather than the waitlisted candidates, where the cabinet note says there may be potential irregularities. Tomorrow, let there be no vacuum. Let people be taken from the waitlisted, subject to outcome, subject to court. The SSC recommendation where they took permission of the court And where they wanted to apparently withdraw it, ultimately they refused them to withdraw and ordered a CBI inquiry. That also your lordship stayed. But this is much graver.
Yes.
So, my lords, our respectful submission is that A, there was no occasion, no issue, no argument. But even on a principle of law, my lords, can such a far-reaching direction in the manner it is being given, be really be sustained, apart from the fact that here no one argued this point? I'm extremely grateful, my lords, for your lordship's kind consideration.
Who would be answering this petition?
My lords, our only other issue
Mr. Gupta, you are also on the same side?
Yes, Lord, I am for the commission.
My lords, our only other consideration will also be this, we lordships may keep in mind, that today it's not even CBI's case that 25,000 illegal appointments have been made. In one rush to cancel everything, my lords, creates and leaves the state with a situation where there's a huge vacuum, the teacher-child ratio, various other requirements under that, everything today goes for a 6 because suddenly en masse you say that 25,000.
That's on the second issue whether segregation is possible.
Yes, that's a segregation. Only? Yes. That is the other point which we are extremely concerned about. Very grateful.
Yes, Mr. Gupta.
Yes, my lord. Just 2-3 facts, my lord. First of all, my lord, the advertisements are given out, my lord, in 2016 for this batch of recruitment. There are 4 batches, my lord, 4 categories of persons to be appointed. First one, my lord, is class 9 and 10 teachers, assistant teachers of class 9 and 10, for which there is a rule of 2016. Secondly, my lord, teachers of 11 and 12, for which also there is a separate rule of 2016. Similar rules. Thirdly, my lord, Group C and Group D employees. Clerical and, my lord, subordinate. Most of the appointments, my lord, were completed in 2018.
Which is the 4th category?
4th category is, my lord, C. 3rd category is C, 4th category is D. Group C, Group D. Clerical and subordinates. Non-teaching, yes. My learned friend is right, my lord. The 3rd and 4th categories are non-teaching.
Yes.
Now, my lord, the appointments were given on various dates after counselling. My lord, mostly in 2018. And, my lord, they started working from 2018. In 21-22, my lord, the writ petitions started coming in. By this time, the panels, validity of the panels had gone.
How long was the validity?
My lord,
1 year.
Different dates, my lord, but 1 year with my lord, 6 months extension possible in certain cases, and my lord, in some there is no date, my lord. There is no, my lord, period mentioned. Now, in 21-22, my lord, these matters were brought in, my lord. There was a series of orders by the learned single judge, some of which came to this honorable court, my lord. And one of those matters, my lord, one batch, by an order of 9th of November 2023, was, my lord, remanded, but not to the judge, but, my lord, to a division bench. Now, this did not cover, my lord, the whole batch of matters which were before the High Court. It covered some. This went to the division bench. The division bench has taken this, my lord, stand. This is the judgment which is before your lordship today. Now, my lord, this is the first appeal. The learned single judge did not dispose of the matters. Before that, your lordship said he will not dispose of these matters. It will be disposed of by a division bench. So, my lord, the division bench disposes of this matter for the first time. And this, my lord, is the first appeal we have. Now, what is the substance, my lord, of this order? Your lordship has seen, my lord. First of all, the issues, if your lordship sees, and then I'll go to the directions. The issues are at paragraph 118, page 187 PDF. And my lord, on the side, I'll put the answer also, my lord. Now, just see, my lord, does this division bench have jurisdiction to hear all the writ petitions and appeals listed before it? This was because this hearing was set up pursuant to a particular order of this Honorable Court, which dealt, my lord, mostly with the OMR sheet problems. And, my lord, the learned Chief Justice was directed by your lordships to place it before a bench. Now, the learned Chief Justice, my lord, passed an administrative order, and, my lord, it was placed before this division bench. The first contention was that this means that a particular batch is before this court, not everything.
The entirety.
Right.
Yes.
Well, I'm not making too much of an issue with regard to that because the court said, let us treat it as a PIL. But, my lord, the result is, my lord, that there are many matters still pending before the single judge on this very batch. There are many matters pending before the appellate court, and there are several matters pending in this honorable court. And now, my lord, there is an actual conflict between orders of this honorable court and this judge. My lord, I am only pointing out, my lord, that it is not possible, my lord, for this matter not to be heard out. Notice, my lord, and your lordship must hear it out. My lord, that's, my lord, where I am going now. Now, then, my lord, that was the first one. Answer is yes. your Lordship sees at 118, whether they have the jurisdiction, answer is yes. I'm just saying, my lord, the judgment says. Second one is, are the writ petitions maintainable at the behest of unsuccessful candidates who have filed the writ petition subsequent to the expiry of the validity period of the panel? Answer is yes, primarily on the basis that we are taking it up as a constitutional court. It's a public interest litigation. So the maintainability will not come in the way. Then, my lord, can appointments be made subsequent to the expiry of the validity period of the panel? Now, my lord, this is not investigated at all. In one particular line, my lord, it is just said casually that it can't. Now, my lord, there is a factual background to it. Sometimes there is a rule backing it. Sometimes there is an executive order backing it. And there is a reason for, my lord, the extension. Because, my lord, for various reasons, my lord, the actual counseling had got delayed. And, my lord, there was COVID also. So, therefore, that is no. The answer is no. 4, my lord, is the certificate dated 19th of September 2022 valid and admissible in evidence? Answer is yes. And I'll give you a lordship.
Gupta, you are paying for the commission, right? You didn't create these supernumerary posts. It's really the state of
Supernumerary post is one small aspect of this matter, my lord. Very important, no doubt. The state is concerned with that, my lord. But the real substance of this matter, my lord, is the cancellation of the my lord appointments. I will come to, my lord, the directions now to show your lordship, my lord, that this kind of a far-reaching order, which affects, my lord, a huge number of people, which is blatantly unfair on the face of it, because people who have actually taught for 6 years are being told that they have to give back the money that they have been paid as remuneration.
So we are now arguing the broader aspects of the matter.
No. These are directions. I'm asking for stay. I'm asking for notice and stay, not broader aspects.
Now, when did you destroy the OMR sheets? Is there provision as to how long the OMR sheets are?
There is specific provision. We are supposed, Rule 21 is there. We are supposed to, my lord, ensure that digital copies are maintained. Digital copies were maintained. Of course, my lord, it has been recovered from, my lord, an employee or an ex-employee of the concern which was asked to scan it. Now, regarding that comes, my lord, the fourth, my lord, question or issue. That gentleman has given it to the CBI that, with a certificate. My lord, the court said there should be a certificate under 65B of the Evidence Act. So,
but you gave the scanning work.
Yes.
To that NISA.
Yes, correct.
Right. Now, yes. NISA appoints that data scan tech.
Yes.
Your
we don't know that, Lord.
Your chairperson says I'm not even aware of the appointment of data
That's
scan.
Correct, Lord, but this is not an outsourcing. NISA retains full control, my lord, who they are sending to my office to scan it actually. Whether it is an employee of NISA or whether he is using some other person to do.
You appoint NISA without even a tender.
No, my lord.
You just forward the contract to NISA.
All this, my lord, is the kind of, my lord, overriding statements which are there in the judgment. NISA was appointed by way of a limited tender, in the sense, my lord, that several organizations were asked to quote, and this was found to be the best quote. 4 organizations were asked to quote. Your lordships have said as early as 1986 in Sachidanand Pandey that it is a valid method by which the government may, my lord, farm out work. There can be a limited tender. It's a very specialized job. It did not require a global tender, my lord, according to us. And, my lord, the whole thing is, my lord, that they have come. They took the contract. Who actually went into the office and scanned it, my lord, was their concern. We have no relationship with data scan. Now, so therefore, my lord, ultimately.
Now the OMR sheets have been destroyed. You say that because under Rule 21 they had to be destroyed.
That's right.
But even the mirror images on the scanned sheets are not in the SSC.
That's right, my lord. It was, my lord, being accessed from NYC. It was being accessed because, my lord, people would come with queries. After the date of destruction of OMR sheets, when people came with queries, we took the data from that organization and gave it to them. Now, my lord, just for a moment, my lord, my stand on this OMR sheets digital data is, my lord, that we have proceeded on that basis. When the CBI obtained the digital data and my lord, the court said you should back it up with a certificate under 65B. The commission thereafter proceeded on that digital data. So, my lord, it is true that there are many parties before your lordship who are arguing that 65B has not been satisfied. So, therefore, this digital data is not to be looked into. But, my lord, the consequence of not looking into it is that then there will be no evidence to show that there is a discrepancy between OMR and the, my lord, what is on the final marks in our server. But we are not saying that. We are saying we have accepted those and we have looked into it, and based on that, my lord, the segregation is to be done. So, my lord, 65B, my lord, is something which will be argued by other persons. The commission, my lord, has so far actually said, all right, very well, we will go by what the CBI has given us. So that is, my lord, issue number 4. My lord, may I show, my lord, the 5th issue? Should the OMR sheets available in the seized hard disks be uploaded in the server of SSC to compare with the final list stored therein? Answer given by court is yes. And, my lord, apart from, my lord, the question as to whether this should be made available to the public in general, 22 lakhs, my lord, or whoever is interested, we have no grievance with, my lord, uploading it and comparing it.
Now, Mr. Gupta, if you go back to now para 335 at PDF 298.
Yes, ma'am.
Where the court sums up what it has found.
Yes.
Let's just read para 335 at page 298. This is your chart. The evidence placed before us have established the following illegalities in the selection process.
Right, my lord. 335.
Yeah, just read.
I'm going to place this, my lord. The evidence placed before us has established the following illegalities in the selection process. SSC has appointed an agency, NISA, for the purpose of scanning and evaluating OMR sheets by a closed-door tender process in violation of 14 and 16 of the Constitution of India. Answer is no, because Article 14 and 16, your lordships have said, allows limited tender process. The judgment, my lord, and there are several.
How many bidders were there?
My lord, there were 4 bidders.
So why did you not issue a proper tender? You're doing something as sensitive as the appointments to the SSC.
My lord, your lordship may come to that conclusion. I'm not saying. Today we are arguing for notice. It has not been considered. The court says closed door. There is, my lord, a legal concept which is missing in this analysis, and that is of a limited tender. A limited tender, my lord.
Let's first read
yes,
the whole para.
Right. I'm just answering as I go along, my lord, if your lordships will permit. Otherwise, I'll read first and then.
That's okay.
Yes. Number 2 is, my lord, such agency has engaged another agency, namely data scan to scan. Now, this is not illegal, and we are not aware. They are getting their job done. They have not.
Surely the Staff Selection Commission must introduce a condition that you will not hand over this to somebody else.
No, my lord.
Because these are matters of confidence, of trust.
Most certainly it is a matter of confidence.
You have to say that, look, you will do it yourself. Otherwise, don't bid for the project.
My lord.
The fact that you did not prevent outsourcing shows that you had just turned a blind eye to the whole sanctity of the process.
Millard, no, this is not a case of somebody coming and saying, I'm introducing a new person. This is, my lord, NICE doing its job, and I am not, my lord, aware that there is another organization which has got involved in it. This didn't come to our attention till the matter was going on. So therefore, my lord, as far as we are concerned, my lord, NICE executives were in our office doing the scanning. Now
just think, we'll continue 3, 4 and 5. We'll just
now 3. Although scanning was done at the office premises of SSC, it is claimed that SSC has never engaged data scan tech. Naturally, my lord, we are saying the data scanning was done by NICE. Now, NICE says that the actual operative...
But when data scan tech's employees enter your office, surely you know that somebody else is entering my office to do the scan.
Not disclosed, my lord, not disclosed.
But if your staff is there, your staff is supervisory. For instance, we have scanning agencies in the Supreme Court.
Yes, ma'am.
That scanning agencies, people come here for the purpose of scanning. If they induct somebody else, it's our responsibility to know if there's a third party which is entering into our premises.
Yes.
Because our supervisory control, our officers are doing the supervisory control over who is the authorized agency who is entitled to do the.
Milord, I'm very sorry, Milord.
Somebody-
No
they-
third
they
party is
start
entering.
enforcing. Our staff cannot say, well, I don't know who else came in because you have.
I know who came in. They came in as nice employees. There is no indication that the person concerned was somebody else and not nice. That's not meant to be, Milord, a pun. Now, Milord, so Milord, data scan, Milord, in my respectful submission is a red herring because the work is given to
Now
nice.
see what follows.
Yes,
Four.
right. Milord.
SSC
Four. SSC has destroyed the original OMR sheet ostensibly with scanned mirror image thereof being preserved in its server. Now, Milord, destroyed in accordance with rules, Milord, we say.
Right.
Your Lordship may consider that. That's all. CBI did not find any scanned mirror image in the server of SSC. That is true. Because, Milord, we relied on, Milord, the person and the NICE gave us the data at all times. Even today, Milord, NICE is giving the data. Whether, yes. Whether, Milord, it is from an ex-employee, whether it is covered by a 65B certificate, all those are questions. But, Milord, the data which the CBI is using, which I am using, all that data has actually come from NICE. Now, Milord, C6, OMR sheets have been destroyed without scan. So, Milord, therefore, there is no.
Now, when you destroyed the OMR sheet,
Yes.
it was the Staff Selection Commission's duty to ensure that the mirror images are preserved in the server.
So, Milord, if the
now there is no mirror image in the server at all.
So, Milord,
because your case is that, look, I was duty bound to destroy it after a certain stipulated period. But equally, it was your responsibility as the SSC to keep the images, the scanned images in the server.
Milord, fair enough, Milord. The question that you're
not... They're not being preserved in the server.
But, Milord, it is being preserved.
Where?
In NICE.
No, but CBI doesn't find it in your server.
No. The digital information is to be preserved.
But in your server.
Now, it has not been found in my server, but it is found, Milord, where it was taken.
But it's worse because NICE at the highest is only an outsourcing agency. Imagine your entire data is now found in the server of an outsourcing agency.
So now, Milord, would
your
Lordship...
Can there be a greater breach of security protocols?
Milord, would this be enough, Milord, to set aside, Milord, the employment of 25,000 people is the question. Now, these three paragraphs, Milord, are actually one point itself. One point.
Then of the whole process.
So if CBI is proceeding on that basis, CBI is taking that data only to prosecute.
Now, if these were destroyed, look at 7.
Yes.
SSC had provided scanned OMR sheets to RTI applicants in the year 2018 till 2020.
Nice, my lord, from NICE. From NICE.
So that means you knew that the entire data was maintained with NICE.
Of course I did. Not data scan. It was not maintained with data scan. It was maintained with NICE.
What was maintained with NICE?
The data, the entire data, digital OMR data.
But how can that means that you are the statutory body? You allow the entire scanned data to be maintained by an outsourcing agency. It's only a labor provider to do the scanning.
But today, my lord, that very data is being used in a prosecution. So, my lord,
but today we are looking at your breach of your statutory.
Well, my lord, your lordship may look at my breach.
Yeah.
I am only going to show your lordship, my lord, what is the actual.
You can't say that, look, NICE took it away. You are responsible for maintaining it. It is people's data. It is people's data.
Please don't misunderstand. I am not, my lord, blaming NICE. I am not blaming NICE. I am even accepting, my lord, that without a 65B or not.
Now see what follows.
My lord, just
higher than the declared.
My lord, if I may just add one thing here, my lord. My lord, if I may just add one thing, my lord. This very data.
In 7, they say,
I'm not
SSC.
I'm not running away from a single clause. Just let me finish this submission, my lord.
Yeah.
That the very data that is being used by this court in this judgment and the data which will be used in the prosecution by CBI has completed its investigation. It has said so to the court that we have completed the investigation. Charge sheets have been filed. Now, my lord, that is going on. Now, question is, my lord, this very data is going to be looked at for both the purpose of this judgment and that. So, my lord, the authenticity of this data is not going to be under challenge.
Now see 7.
Yes, my lord. Now 7. SSC has provided scanned OMR sheet to RTI applicants claiming that such was from the database, although CBI did not find.
So
my lord, we are saying that
you have responded to RTI queries,
yes,
saying this is from my database.
No, I don't know whether it said mine.
Yes.
Just said database.
No, from your database. And now it's come to light that this is not in your database at all. That means what you were saying to RTI applicants that, look, this is in my database.
So
that is incorrect. Look at the Staff Selections Commission's modalities of conducting it, Mr.
Milord, it may be, Milord. It may be, but that same very data is being relied upon. Today, this judgment would go if you take away that data. It will have to be set aside. Because, Milord, in one chapter...
But there is no data at all.
Suppose there isn't, Milord. Suppose there isn't. Then what will happen to this judgment?
But then the appointments have to go.
Yes. Milord,
because either you have the data.
Yes.
If you don't have any data, we understand that OMR sheets in the physical form, you can't maintain them in eternity.
Yes.
But then two things. You are duty bound to maintain the underlying documents in a digitized form.
Yes.
Because now today with digitization, it obviates the requirement of all that storage and everything.
True.
Now you say that, look, I don't even have the, you provide RTI responses saying this is from my database. Now it's obvious that there is no data in your database.
All right,
Milord.
All I'm saying is, Milord, that I am
is
saying...
the only agency.
All right.
NICE appoints data fintech.
No, Milord.
You are unaware of the fact that your service provider has further subcontracted the service to somebody else.
Milord,
surely
you
had to keep supervisory control.
Milord, very well, Milord. I am not, Milord, on that. I am saying that the very same data which your lordships, Milord, are doubting is the basis for the CBI prosecution and this judgment. So if your lordships, Milord, are not to look into that data, Milord, then this whole judgment has to change. It may still lead to, Milord, investigation, but it cannot be, Milord, what is happening now.
Now, appointments higher than the declared vacancies have been given in respect of all 4 categories.
Appointments higher than the declared vacancy have been given in respect of all 4 categories.
Appointments given to persons who are not even in the panel.
Yes.
Appointments given to persons who submitted blank OMR sheets.
Yes.
Appointments given to persons after expiry of the panel.
Yes.
Persons placed lower in rank had been given appointment in preference to persons placed higher in rank in the merit list.
Yes.
Merit list containing marks obtained by respective candidates have never been published.
Yes.
Counselling had been held subsequent to the expiry of the panel.
Yes.
Total beneficiaries of the illegalities are yet to be identified and rendered improbable given the stand of SSC board in the state. SSC had applied for permission to create supernumerary posts to accommodate the illegal appointees, and recruitment rules governing the 4 categories had never been adhered to either in letter or...
No, that last one is a conclusion.
That's it.
Now, Milord, I have made a chart. We have exact data as to which category which appointment falls into. And Milord, we are not defending. We are not defending appointments which have jumped the list. We are not defending those appointments which have come outside the panel. We are not. We are saying, Milord, that the 16,000 of this 24,000, 19,000 of this 24,000 are not tarnished by any of these clauses. And it is very easy to demonstrate it. It is very easy to demonstrate. We have prepared the chart. The chart will show, Milord, that out of this 24,000, 19,000 were appointed from existing merit lists in accordance with the merit list, within vacancy, within time, everything. And Milord, we were the ones who came forward and gave that data to the court, saying that these are not certain Milord, appointments cannot be justified.
So according to 19,000 are within the merit list.
At least, Milord, that is our rough, Milord, estimate at this point of time. And we told the court that we are prepared to do this exercise all over again. Please see one paragraph only of the judgment, Milord. Milord, page 99. I think your lordships are looking at another SLP, but I am on, Milord, paragraph 33. My pagination, because I'm in 10.1, may not match, Milord. But look at 33. In fact, my lord, I'm sorry.
Page 124 above.
124 PDF.
ফাইনালি পৌঁছতে পারবে।
Which is recorded in the judgment.
How do you displace these findings, Mr. Gupta?
Millard, I'm not displacing all those 4 categories, Millard. I have segregated now.
But look at it's a systemic fraud.
Millard, just look at the directions then, Millard. Is this fair? Look at the directions now.
And ultimately, Mr. Gupta, what happens is this.
Yes, Millard.
Today, public jobs are so scarce.
Yes, Millard.
And so valued.
Yes.
That if the faith of the community in public employment goes,
yes,
then nothing remains. Yes. Because today, public jobs and public employment is extremely valued.
Yes.
It's a source of social mobility for people coming in from the lower strata.
Yes.
People only aspire that, all right, my daughter and my son will get a government job. If this is the way, we are virtually purloining public employment. What remains in the system?
But Millard, your lordships have said.
How do you displace these findings?
Millard, your lordships have said so in several judgments that if it is possible to segregate, we will not set aside the panel. I'll just show you, lordship, just 2, Millard. One is your own judgment.
Right, where I think Madhu Diwan had appeared.
Yes. And I'll show you, lordship, one other paragraph, Millard, from another judgment of the same year, 2021, which says that even if...
Interestingly, that was a case where the entire process was set aside.
Yes, correct.
Yes.
But here, your lordships have also had occasion to say that even if there is a small possibility that it is possible to segregate, we will explore that possibility. Because on the one hand, what your lordship is saying is right, that people, my lord, have an expectation of public employment. On the other hand, my lord, these very persons will be on the street.
But you have nothing to show that this is the data which I have maintained.
My lord, I'm sorry, my lord, if this
Where
data is...
What do you have within your system? Any traceable record to show that this is the data I have maintained?
My lord, the prior chairman of this organization is being prosecuted on the basis of that data. Surely, my lord, if your lordships were to cast doubt on that data, then no criminal prosecution can be based on it. My lord, let us, my lord, proceed on the basis. As far as I am concerned, my learned friends may have some other argument, but let us proceed on the basis that the digital data which the CBI has obtained is going to be relied upon. It is another thing that it has come from the custody of the outsourced person. But it is being relied upon by a law court.
All right. Anything
In
else?
para 30,
We'll have to hear the others also.
yes,
now.
Milord, I'm just give me 2 minutes, Milord. In para 33, we have said that we can do the job again. So, Milord, it is not correct to say that we did not offer to do it again. Para 33 has recorded it. The second point is, Milord, para 240 is the only statistical analysis of page 229 PDF, para 240 of item 10.1.
229.
229, yes, Milord. Paragraph is 240 of the judgment.
1 second. That is the wrong.
No, that is because, Milord, your lottery probably has 10.
240 PDF. 240 PDF. 240.
Para 240, Milord. Page 229 is in 10.1. 240, yes. Now see, Milord.
Para 239. Para 240.
240 is a chart. Milord, I am showing it, Milord. Why is my learned friend getting agitated? Milord, just see, Milord. Alleged irregularities in percentage, 8.5 for assistant teachers of 9 and 10, 14.7 for 11, 12. The other two are very high. Now, the problem with this order is, Milord, to bunch and put everybody in the same basket. Second proposition, Milord, this is the data taken from, Milord, the CBI record. Now, are we to rely upon it or are we not to rely upon it, Milord? That's the question before your Lordship. If we can rely upon it, Milord, segregation is possible. If we are not to rely upon it, then, Milord, there is difficulty.
Yeah.
But then, Milord, the judgment doesn't stand. Some other recourse has to be sought, Milord. Even then, Milord, your Lordship will have to go into the question. Milord, just 2 more points, Milord. I'll sit down. Milord, No. Milord, very important point, Milord. This segregation has to be done inevitably even under these directions. Just look at direction number 4. Of course, Milord, we are submitting that this is an unfair order. Even if, Milord, everything is correct, it is still unfair to say give back the money which you earned by teaching. But see 4. Persons who have been appointed outside the panel after expiry of the panel, as also those who submitted blank OMR sheets but obtained appointments, must return remuneration. With interest. So only 3 categories have to remand it, give it back, refund. So the segregation has to be done. And upon segregation, there will be a large group of people who are not required to give up the fund, the payment. Now they will be faced with a situation that they have lost a job. but they are not held responsible. My lord, two more things, my lord, I'll sit down. Now, my lord, this 8th direction or the 7th direction, 8th direction, your lordship has already stayed. The 7th direction, further investigation by CBI in respect of all the 4 cases, meaning the 4 categories. My lord, on 9th of January 2024, a comprehensive report was given by CBI saying that they have completed inquiry, investigation. And final charge sheet has been filed. Now, my lord, by what process, my lord, can the writ court say you reopen that investigation now? My lord, that statement by the CBI, my lord, is contained in 9/1/2024, page 743 PDF of, my lord, item 10.1. I've run out of time.
Yeah.
Last submission. Yesterday, my lord, we have sat and found out various categories. As I told your lordship, my lord, the categories include those who have been recommended as per merit list and some who have been appointed pursuant to orders of court. So these 2 categories, my lord, should not be, my lord, subjected to, my lord, this cancellation is our submission.
Yes.
Secondly, my lord, as far as the period of the merit list, validity of the merit list, my lord, that we wish to defend. Because, my lord, in some cases there are rules, in other cases there are executive orders for stated reasons. We wish to defend that beyond the period.
Yes.
We do not wish to defend and we wish to segregate persons whose OMR data, digital data does not match our server.
Yes.
We do not wish to defend persons who were appointed from the waiting list, not in accordance with rank. Rank jumping is the phrase, my lord, used here. Summarizing.
Yes.
We do not wish to, my lord, support anybody who is not in the panel and has got appointment.
Yes.
And, my lord, there are some people who have been appointed without our recommendation at all. Those also, my lord, we are not defending.
Yes.
My lord, I'll just give your lordship the judgments. Your lordships are aware. 2021, 4 SCC 631 is your lordship's judgment. 4 SCC page 631, paragraphs 35 and 55.
Yes.
And 2021 7 SCC 613, 7 SCC 613, paragraph 73.
Yes.
Which says, my lord, that if it is even possible, then one should prefer to segregate rather than cancel the whole. So, my lord, this is my submission.
Yes, Mr. Ranjit.
Something shocking has come, sir.
Lord, may I please be excused, my lord? If your lordship requires, my lord, I'll come back.
SST.
Lords, I appear with Mr. Ghosh for the West Bengal Board, my lords. The Board of Secondary Education.
Yes.
My lords, we are the ultimate beneficiaries of the process because we get staff entirely through the Staff Selection Commission. And whatever they recommend or whoever they recommend, we normally appoint. My lords, today, my lords, in the state of West Bengal, I believe there are about 132,000 teachers. And this judgment affects about 17,000 of them, at least. Almost 18,000, I'm told. So that, my lords, is almost 1/6 because this also is a specific category of teachers from the 9th standard onwards. My lords, there is nothing in this judgment about great irregularities on our part, so there is nothing that I wish to open further. My lord, I would join in the request made by counsel before me, my lords, that where segregation is possible, in the interest of continuing education, and also in the interest of the state that it should have reasonably trained students, teachers. So
bear that in mind.
Yeah, they have had 6 years of experience. Now, what will happen, my lords? If these people, if we lose a whole chunk or a whole generation in between, we will not have senior headmasters, we will not have senior examiners at a later stage. Right?
I will bear that in mind. The general considerations will bear. Thank you, Mr. Agri.
Yes.
Say, your lordships will also bear in mind the fact that many of these people did not get any notice. Those only those where there were specific allegations, they came to court. They had notice. But it was not as if there was a general notice.
Thank you, Mr. Segregation. Yes, Mr.
Just one more request, my lords. And this is what sometimes, my lords, when there is a headache, you don't cut off your entire head. That's the argument.
All right. Yes, Mr. Andrew.
Very conveniently in late.
Lord, our case is slightly sui generis, Lord, if I may use that expression. For this reason, that we were people who were working from 99, 2007, 2011, 2001. What had happened, Lord, just let me explain. There was earlier a zonal system of appointment of assistant teachers. So the zones were such, Lord, the rules were that if you are in one zone, you can't be transferred. So many of these assistant teachers were far away from their homes, Lord, in the big state of West Bengal. So they got an opportunity in 2016 by this advertisement that they could participate in the selection process. Now, by this participation, quite a few of them have been able to get appointment or posting in a place which is near, because now it has become centralized. From 2016, Milord, the whole process became centralized for the entire state. So therefore, because the entire state became one, so persons wanted to take a try that if I can be nearer, Milord, assistant teachers as they are. So these are persons who sat, they were given no objection to sit for the examination. They sat for the examination, they were found successful, and thereafter they were appointed, they were given continuity of service. Their pay was protected, and their service books remained the same. Now we got notice of this. Sorry.
How many of?
We are 367 persons.
Who were appointed since?
So we placed a chart at page number 733
of
17.6 in item 17.6. Item 17.6, the chart is at page 733 of all the PDF. 733 A of all the 367 people. One person is due to retire next year, in fact.
17.6.
मेरे पास तो है ही नहीं 17.6.
17.6.
I've got 10, no?
The name is Atanu Chaudhary.
Annexure P40.
Annexure, it's P42, P42.
First name is
P40. I'm obliged. Sorry, it is P40.
First name is Atanu Chaudhary.
Yes, Atanu Chaudhary, Milord.
And the internal page is 733.
766, Milord.
733.
Yes, Milord.
Right. Okay.
Yes, Milord. Much obliged. Much obliged. So the first name, if your Lordship just have a look. He was first person was appointed on 11/10/2007 in the 5th column, Milord. Your Lordship will find first date of joining service 11/10/2007 in Purulia. That was the first district as per the zone. Now he has joined again on 26/9/2018 in Hooghly. And his permanent address, if your Lordship see the 4th column, was Milord in Chandan Nagar, Hooghly. So they were given permission to participate. They left their lien and the old job, and they have forgone that job. They have joined here, and they have been working since then for the last 6 years. Milord. If your lordships were to see, my lord, two examples.
Which is this? Which is your SLP?
My lord, my SLP number is 17.6. It is, my lord. My lord, I have an 20729 of 24. 20,729 of 24 is my SLP number, diary number. SLP.
Covers totally 367 persons.
367%.
Where they were appointed earlier, much prior to this 270. They participated in this and they were given continuity of service.
744 is somebody who was appointed in 1999. 744, I have given that, shown that, I can show that example. At serial number 131. And he is due to retire next year. So he was appointed, my lord, on 8/3/1999. And he is due to retire now. So, my lord, these are, I am representing those set. Now, my lord, we got notice of this in November 23 before the High Court. We filed 2 applications before the High Court. That applications are taken note of, but no orders are passed. If your lordship would like to see that paragraph, it is in paragraph, my lord, page 154, paragraph number, my lord, 108. This is all that is stated. We have got annexed the copies of these applications also, with our especially. But I am showing this paragraph of the judgment from the main first paper, the State of West Bengal paper.
Yes.
So they only note that these applications have been filed. Application CA number 23 and 24 was ours. And if your lordship would like to see the particular application, I have put them in my SLP.
Mr. Shubhra Prakash Lahiri.
Lordship, Subhra Prakash Lahiri was our advocate there. We got notice, my lord, your lordship will see the third last line of that para. That notice was December 6, 2023.
But you never said that, well, if this is cancelled, allow us to retain our lien on our earlier employment.
So, my lord, I am putting it this way, my lord.
Your case was of segregation.
Yes, and I am nowhere in any CBI list. In any list, my lord, I am not there. I have been given continuity.
Let me come back after lunch.
Much obliged.
There was never.
Lords, that gaming matters 8 and 20.
Yeah.
Total Council has also sent an email. Mr. Venkatraman is here. We're wondering if you can take it in July.
We've requested for a 15 July date.
Because today we won't be able to.
Yes.
Yeah, today unlikely.
We've sent an email requesting the date also.
For 8 and 20 needs to be formally tagged with item 8. And then.
But 15th is a Monday.
Yes, my lords. Please, because there are some, if it can be at least kept that date.
No, any date.
then-
All right, we'll keep it on the 15th and then we can
very
find a date and get it.
That's what.
Grateful.
Grateful.
So, but there's a line which my lord said would add in my order yesterday.
What was that?
Liberty to move the High Court. I thought.
For what?
This is the case where my arguments have been closed without hearing me.
No, we didn't want to add that.
No, why? The hearing is tomorrow.
We are not giving liberty to move the High Court. If you have that liberty, you can take that liberty. We don't want to create that space.
With the dismissal order, it will become difficult for me.
They withdraw, but now we've passed the order yesterday.
No, that's. I made a request yesterday before.
But we don't want to give you liberty because the High Court had closed your right to argue because they felt that the lawyer had never cooperated with the High Court, didn't want to argue the matter, and they said, okay, we are hearing the others.
I'm sorry, but I was not there at that time. I was in another court. Actually, we had finished arguments before another bench. Then this was another bench.
Pointed out to the High Court.
If my lord doesn't give me that one line.
It's not necessarily the High Court. To allow somebody to be heard, you don't require a direction from the High Court.
What they did is they fixed a date for the state.
Right. So
state also sought an adjournment.
But before the state argues, this does not preclude you from telling the High Court, I want to take 5 minutes to just argue it or tender a written submission to the High Court. There are so many things which can be.
Would my lord consider writing?
Not necessary, Mr. Gantana.
May please, my lord.
May I please mention item
please,
7?
your lordships.
May I please mention item 7? Because that's the.
We'll keep it tomorrow because this will take us through the day today.
Yes. Milos, may I make a request on item 7? That's the matter fixed for today. The visually impaired, the Madhya Pradesh matter. I'm the candidate. The larger issues, there's 7. I'm 7.1. Milos, the difficulties which my laws appreciated, the result will be declared.
What do you want right now? We're in the midst of a matter.
Yes, Milos, I'm only requesting for tomorrow because it's unlikely.
Yes, Kala.
Right.
10 is which matter? This one. Don't make any request in any going on matter. We'll hear it. Whoever is here, we'll hear them. Otherwise, we'll conclude our argument today and we'll conclude it. That's it. Sorry, not at all. Whoever is here today is here today. Be ready here.
Will your lordship be taking our matter first tomorrow?
Yes.
Deeply obliged.
These matters will keep on coming. Whoever is here today, we'll conclude it today. Yes.
I'll give you the diary number also.
Get it verified, registered, etc. Yes. Yes, Mr. Anjit Kumar.
Lordship is grateful. But what I was pointing out about our CA 154, our lawyer, your lordship mentioned, Mr. Lahiri is here also. Unfortunately, he happens to be here, who was there before the High Court.
Yes.
Mr. Lahiri informs me that everything was placed. Only this has been noted in paragraph 108. And he also informed me that some written submissions were also filed before the division bench, pointing out all these facts about us.
So what happens if you lose your job now? Then will you retain your lien earlier or not?
That's why we have annexed the rules. We had filed an IA also in the main petition, which is listed today, 109747.
So when you accepted this job, you lost your lien.
Yes, I lost my lien. The rules are there. If a lordship permit me,
so you basically sail with everybody else ultimately. There's nothing special in your case. You sail with everybody else then.
The special is this, my lord, that I came here for a better job, in the sense better prospect, and for no financial implication, continuity of service. Some people are to retire next year. Some people will not have been appointed in 99.
Before the High Court was segregation.
Sorry, Lord.
You argued segregation before the High Court.
Yes, my lord. And my lord, if your lordship sees the High Court judgment, kindly, my lord, permit me the 3 options which the High Court itself notes. At page 250 in the main petition, my lord, or even in my petition, page 250.
Yes.
Sorry, my lord. Just give me 1 moment. One second, Lord, please. The High Court notes that there are 3 options before the High Court, and that your lordship will find at page number, my lord, 255, my lord, of the paper book, which is paragraph number 312. PDF page 295. At the foot of the page 312.
In the main act.
Dismiss the writ petition, my lord.
Yes.
Dismiss the writ petitions on the ground of maintainability or explore the possibility of segregating the valid appointment from the illegal one or set aside the selection made in the selection process in the entirety.
Yes.
So the High Court did have kept these three options, my lord, in mind. And then, my lord, if your lordship see below that, first option noted above is no longer available in view of the decision rendered on the issue of maintainability. That is on the limitation part, etc., that people came to the British court after, my lord, the expiry of the panel and 3 years after the appointments had been made.
Yes.
And then on the second option, my lord, the consideration starts from page 314, para 314, and if your lordship will kindly come on this aspect at page number, what they say, my lord, in para 321 and then 323. In respect of the four categories of the selection process involved, written examination has been held. Written examination in the form of OMR sheet. Original OMR sheets have been destroyed. Mirror image of the destroyed OMR sheet was required to have been preserved. CBI had seized the server of SSC and did not find any mirror image of such OMR sheets. So SSC and authority within the meaning, etc. I'll skip that. Now kindly come to 323. See, significantly, it is a claim of the SSC that scanning of the OMR sheets had taken place at the office. If that be so, then SSC had knowingly allowed another organization to scan the OMR sheets, namely so and so, who was not authorized. This raises serious questions as to the integrity, sanctity, and validity of the entire selection process and going to the root of the system. So this is the basis for not segregating, my lord. The second option, not opting for the second thing, that whether we can segregate. And then 260, para 330 onward, the third option is considered thereafter. So I am respectfully submitting, my lord, that I am not in any CBI list. There is nothing, no such thing against me. There are government orders. I have. At page 703 in my paper book, in my 17.6 item, we have annexed the pay protection granted by the government, and the carry forward of the service book is at page 705. 703, statement of protection, and thereafter approval of that fixation of pay and protection by a superior authority, and then the service books are from 705. We have annexed one of them because there are 367 people we have, and that's why we have put it in a chart. So it shows, my lord, memo of 2008 at serial number 11, if your lordships have 703. And then 2014, and then the current. And over the page, my lord, is the approval letter. At the top of the page says approval of fixation of pay for protection of pay in respect of in-service teachers. So we are called in-service teachers, my lord. And that protection of pay happened on 16/12/19 at the foot of page 704. And the service book of this first petitioner is at 705. So, but I am, Millard, so therefore I have started by saying we are a sui generis category, Millard. Because we are not somebody who has in-service candidates were allowed to give, Millard, and if a lordship were to just permit me to show page 389, which was a public notice issued by the West Bengal School Service Commission, allowing us to participate. And of course, I must point out, Millard, that we had to go to the High Court for allowing us to participate, because the scheme for the centralized recruitment happened for the first time in 2016. So we went to the High Court. That High Court order is also on record, saying that yes, we should be allowed to participate. And then, Millard, the public notice came, which is at page 389, which extended the period for filing filing our application up to 7th October 2016.
All right, we'll consider this, yes.
So therefore, Millard, I am respectfully submitting, Millard, that it should not be the same brush, Millard.
Yes.
And now we are all over age. So even if, Millard, fresh election were to take place, we as in service can't even apply. And one is to retire next year, as I pointed out, Millard. Yes. I'm very grateful. Much obliged.
Yes, Ms. Diwan.
May I be excused, Millard?
Yes, yes, ma'am.
Can I follow that order? Because I would be also representing those persons against whom Mr. Brooks.
You are Mr. Pratik there? All right.
But I prepared a short note. Well, my endeavor, since I have also lost the job because of this judgment, my endeavor before your lordship shall be to show the gross incorrectness in the judgment itself.
Yes.
But first, lordship may kindly see the very basis of this judgment, which is challenged before your lordship, was the November's order passed by this honorable court. In the order, there are 7 fundamental directions which were required to be gone into and followed by the honorable division bench. Lordship, kindly take the first. I have just jotted down that. Now, the first point was, Lordship may kindly put a difference between two situations. Usually, my lord, whenever the matter is heard by your lordships, lordship send the matter, then there is an expectation that the matter will be decided on merit. But there are only few cases when your lordships feel that not only the merit is to be decided, no matter it was pending for last 3 years, 4 years, etc., but also the point of maintainability is to be decided, then, my lord, my respectful submission would be that there should not be any prejudice as long as this order stands. So the first part of the order was though there has been detailed documents, all points, this Honorable Court felt for whatever reason that there is a necessity to first decide the maintainability of the writ petition itself. The second was to examine the admissibility of the OMR sheet images. Third was in November 23, when all the documents, affidavits by the CBI and School Service Commissions, everyone was before your lordships, there was an observation in paragraph 8. At this stage, no such outstanding case, because Justice Gangopadhyay passed an order for termination of the large number of teachers. So this was the observation by your lordships. Fourth was, these allegations would have to be established through evidence. Well, I would correlate on this score how the Honorable Division Bench have completely gone incorrectly. Fifth was, well, this is important, to ignore the findings of the earlier Division Bench on Rule 17 plus to decide afresh. Lordship may kindly connect this with the point of maintainability. Because the situation at that point of time, my lord, before this Honorable Court was that the Honorable Justice Gangopadhyay directed the School Service Commission that you must invoke your power under Rule 17. My lord, School Service Commission is a recommending authority which is governed under a particular rule, for the time being 2016 rule. Once someone is appointed on the basis of a recommendation, as an employee, I am governed under 2018 rules, which is a separate rules altogether. A point was taken before the High Court, before the Honorable Justice Gangopadhyay, and also before the then Division Bench, that once the recommending authority recommends and thereafter an appointment is done, the recommending authority becomes functus officio. But there was a direction by the Justice Gangopadhyay to the recommending authority that you invoke Rule 19, Rule 17, by which you terminate all the ballot, whoever at that point of time the court found that their appointments were illegal, invoking Rule 17. So that point, whether that would be done or not, that was required to be decided, that your lordships held. Now last one, and the next page, CBI to complete investigation and submit its report. Well, this is very important. Lordship may kindly see that after this order, this was a November 23 order. After this order, well, what is usual and what is expected is that the CBI will file a report before the Honorable High Court saying everything, whatever they have got to say. But there are 3 reports which were filed by the CBI. First report was of dated 9th of January 24. That does not contain anything of 65P, anything of scan take, anything of whatever is found to be fundamental today before your lordships. Nothing. Absolute absence. Thereafter, after 19 days, second report was filed by the CBI, 16th of January 24. Lordship may be surprised to take note, in the entire report, there is not even a single word on scan take. I have seen that on the very first day when this matter was moved, one of the basic points that was expressed by your lordship, that how there can be somebody who was not even getting the tender, that's a scan take. So that's an important issue. So after 19 days in the report for the first time, my lord, first 9th of January, nothing. Not even the 65B certificate. Despite November order, there is a requirement to prove it admissibility. 16th of January, no whisper, no word, no sentence, no document on scan take. Last report, 5th of February 24. Now, Lordship may kindly look at 2 fundamental, according to my understanding, flaw. My lord, after the amendment of the Evidence Act of Section 59, if a particular record happens to be electronic record, the only way of that electronic record to become an evidence is 65B and 65B alone, as held by your lordships in Anwar judgment. Now, there are two sets of electronic records, as per the last report of the CBI. One Scantic, one Pankaj Bansal. Lordship may kindly have a look at, my lord, I am referring to the state SLP for the convenience, page 768. Lordship may kindly have a look at this. This is signed by authorized signatory Sri Pankaj Bansal, data analyst, Messrs. ND Infosystems Private Limited. Well, I could have understood. My lord, if I can give an
So
example.
what's the drift of your argument? We're not able to get-
May I just say and then?
Yes.
I was just thinking of a situation, my lord, as a counsel. Now, if I sign here, I am signing in the capacity of, my lord, as a counsel, as an advocate. When I go to my son's school, when I sign there, that signature is not, my lord, in the capacity of a counsel. As a parent, I am signing. I do not say that Pankaj Bansal could not have signed in the capacity of an ex-employee of NISA. I don't say so. I say that this is having not done so. Can you have a look at, my lord, who has signed it? Signed, I read it out. Authorized signatory, Sri Pankaj Bansal, data analyst, Messrs. ND Info System Private Limited. Well, this document is absolutely nothing.
There is an absence of data.
No,
That's the whole point.
that would come. It's not correct. That's not correct. First, what I submit before your lordship is this. In November 23, this Honorable Court wanted the High Court that look at the 7 points, decide the writ petition, including the point of maintainability. If you have to issue any order on the OMR, first decide the admissibility of this OMR sheets as, my lord, seized by the CBI. Now, what I, my lord, submit before your lordship is this. Your lordships have categorically held that it is 65B certificate and certificate alone. Well, I shall be showing that specific paragraph, not the affidavit. Must disclose what is required in the 65B. Now that will come only after someone, my lord, who is relevant with the organization, he is, my lord, giving a certificate. Today I could have understood a certificate is given by the Scantech. I would have understood a certificate is given by any employee of the NISA. But this certificate is by X, Y. So this has got absolute a zero value as far as the evidence part is concerned. Now, lordship may kindly take, my lord, the last but one page of my note. Lordship may kindly take, my lord, the Anwar judgment, my lord, in the compilations I have given.
We'll see that later. We'll see that judgment later.
My lord, that paragraph 14, if I can read it out, my lord, the relevant portion. Any documentary evidence by way of an electronic record under the Evidence Act in view of section 59 and 65A can be proved only in accordance with the procedure prescribed under 65B. So that's the only way out. Now thereafter, I'm skipping few portions. 14, last two lines, which is called as a computer depends on the satisfactions of the 4 conditions under 65B2. Now, lordship, kindly take last part 1 page of myself. What, if I can use the word, the blunder the CBI has done? My lord, they have stated in the certificate, I have the exclusive possession of custody of the records. What is required under 65B2A is a lawful control, not the exclusive custody. There is no word, because I can take on the face value that, yes, he is saying I'm in the lawful control, that is fine. But there has to be words like lawful control, that's a requirement of 65B2A. Instead of the word lawful control, the word that's there, having exclusive custody. Well, this is the first. Second, there has to be a specific statement in the certificate, my lord, that it is regularly fed plus ordinary course of activity, that is 65B to B, completely absent. My lord, third requirement was computer was operating properly, 65B to C, absent. Last was information equals to reproduction of what was fed in computer in ordinary course of activity, 65B to D. So therefore, the four requirements under 65B absent in the certificate given by Pankaj, who is not even of NISA. One. Other thing is the Scantech, which in the last report of the CBI has said that he has also done better scanning. There is not even any certificate by the Scantech. Now, in this context, now Lordship may kindly come paragraph 335, for which we have lost our job. 330. That's the 17 reasons. Well, I just forgot to indicate one more reason. In the last report regarding the data of the Scantech, Lordship may take note of the fact that what the CBI said in their report, that they see some data in the form of .dat. In the protocol for any scanning, the data has to be in the JPEG or the TTF file. That's the protocol. But it can always be converted to .dat, but that requires another software. The reason for this submission is that technological aspects, a little tweak can make a huge impact. That's the requirement of 65B very stringently. So,
well, we'll hear them on the 65B.
Yes.
Let's anything else?
Yes, my lord. 335, my lord, the first reason that we lost our job, that SSC has appointed the agency, namely NISA, for the purpose of scanning and evaluating OMRs by a closed door. My lordship may kindly consider this. For last 7 years we are serving. I don't have really information, but my instruction is that many competitive examinations, because of the reason that the candidates do not get to know who would be doing the AMR, it is done in the closed door. But I don't have the data. That's the instructions I have got from my clients. Now, High Court could have at least made an attempt to see, is it a unique thing which is done by the School Service Commission in West Bengal, or in all other competitive examinations, the closed door is the common phenomena, because so that the candidates do not get to know this. The second one was why the data Scantech was there. Lordship must. My lord,
Mr. Dar, now let's hear some other people also.
just 2 minutes.
Yes.
My lord, the rule 2016 rule, Lordship may kindly have a look, rule 21. But I don't say that it's a very proper rule. It should have been better. But the rule requires that this has to be destroyed.
But the scanned mirror images have to be preserved.
That is not in the rule. That's not in the rule. That's, my lord, the common sense, I can say. I can say, yes, it's a good thing, it's a transparent. But to say that the rule requires that mirror image should have been there, but that's the findings of the division. That is incorrect. Lordship may kindly have a look at the rule.
There's no requirement of maintaining a mirror image?
No requirement. No requirement. And my lord, the RTI. Rules cannot really supersede the parliamentary step of RTI. May I hand over the, my lord, this 16 rule? And Lordship will not find a single sentence. 24,000 persons have lost their job. Among 149, my lord, as I am representing, there is one wish. But I do say, as a responsible counsel, I do say, my lord, this rule is not proper. That Lordships always come across. It is definitely not proper. But at the same time, as long as the rule is there.
But is it, according to you, is it possible to segregate those who are tainted from those who are not tainted?
Well, there are two ways of looking at it. One, Lordship is assuming that some people are tainted because.
According to you, nobody is tainted. According to you, nobody is tainted.
Well, I am representing that 19,000.
Where do you stand? I mean,
I say on a point of law, when this honorable court directed that you have admissibility.
But according to you, is the entire process without taint, or there are people with?
No, there are, I would say, tainted persons. Who are those tainted? Who have been given appointment after expiry of the panel, number one.
Yes.
Anybody who was given appointment after expiry of the panel, of course, this is illegal, and that can easily be found out from the very date itself, and they should go.
Then?
My lord, if there is...
Apart from this category?
My lord, if there is any candidate who even without participating has got the appointment, must go. It's illegal.
Yes.
All I say, my lord, the parameters of illegality, Lordships, definitely apply. But if your Lordships apply the parameters of illegality after observing or finding that there is a sacrosanct electronic records, that is absolutely right. And therefore, what is the wrongs has to be found out after seeing what is the mismatch from this one. That is only permissible once that electronic records are found to be correct under 65B. But on the face of it, tomorrow somebody else gives a certificate. This would be, my lord, allowing an amendment to the 65B itself. And to that effect, my lord, the only submissions by the counsel of the CBI was one paragraph in his entire judgment, paragraph 29. We have submitted our charge sheet, matter is pending. That's all. There was no answer to my very fundamental point that this is so important, can take, NISA. Why didn't you say so at the first time? Why didn't you say so in the second time? And why you are saying at the last time? But I have a probable answer. They knew that 65B certificate signed by someone, some MD electronics, that is legally, that has got no value, zero value. That's the reason in November 23, they did not show it before this honorable court. That's the reason in the first report, they did not annex it. Only in the second report, they annexed it. And in the last report, my lord, a new story of the scan take came, which I said that there they are referring to .dat format, which is a processed. My lord, today, I am also representing my lord, visually challenged candidates. about 100, though only one person has signed and is before your lordship, they have also lost a job because of this judgment. My lord, my respectful submission before your lordship would be that the criminal case is pending. Ultimately, it would be decided who has done what and he must be punished. Prior to that, in a writ proceedings, whoever has jumped the panel, they should also go. But other than basing that this is the CBI record so sacrosanct may not be a proper interpretations of.
Thank you.
These are my responses.
Yes, Mr. Who's now going to argue? Maybe the next counsel under the Mr. Rohadgi is here.
I am there.
All right. Now we have Mr. Madiyal, right? With
I
Mr.
just
Rohadgi.
take 3-4 minutes. I'll not take more than that. Much of what I
1 second, we'll go. No. We'll go by the rules. So we'll go by what we have got the record now. No interventions. Yes.
I appear in item 17.2, 10.5, 17, and 18.
All right. What do you have to say?
Yes, my lords. My submission is that segregation was possible and it ought to have been done. The petitioners in these matters, my lords, are all persons who are completely untainted, even if the OMR is to be taken as correct. The mirror image of the OMR is taken to be correct. In fact, if my lords have para 240 of the impugned judgment, the SSC 240, that is para 240, PDF perhaps 243 minutes. 249. There is already a segregation that was placed before the Honorable High Court.
249.
Yes, para 240, my lord, sir.
The page?
Page
PDF?
200, PDF page is, I think, 249 of the state's SLP. There's a tabular column at the bottom of
para 249.
No, para 240, PDF page 252, I'm told. PDF 252. 243. 252 of the state SLP. Yes, so there is a segregation, and my lords may just note at the right-hand corner of that table, the discrepancy found even, for example, in 9th and 10th level is just 8.5%. The CBI finds, my lords, discrepancies after examining the OMR sheets, the mirror image, in respect of about 953 candidates, in respect of most of whom there was, my lords, a withdrawal order issued, which was stayed by your lordships over here. But my only point is that segregation was possible and segregation was done. And therefore, my lords, today in the 9th and 10th level students, there were 11,610 candidates who were selected. Out of that, my lords, as per this table, I am going by this table.
Yeah.
As per that, even according to the SSC in this, the alleged irregularity was only 993. Therefore, my lords, if segregation was possible, as the SSC has told your lordships today, it is possible. The CBI has identified those individuals. The SSC before the High Court has placed data identifying those individuals. There would be no reason, my lords, to paint all of these candidates with the same brush. And to remove them. This would especially be so, Malaj, because 2018 these individuals have been appointed and are continuing to work.
All right. Thank
Grateful.
you. Mr. Diwan?
Well, it's just one suggestion, one aspect. Malaj, your lordships may also consider if segregation, if today the data which the CBI has is to be examined even by an independent committee to see if that segregation is valid or not. Grateful.
I have two sets of submissions to make. The first is in the petition, which is at serial number 19.3. It's titled Chinmoy Mundal. Now, may I just make my point here? There are three petitioners here, three SLP petitioners before Lord Trooper in this particular petition. None of them were parties before the High Court. And we've therefore come here with leave to appeal this particular judgment. Now, I come in what can be broadly described as that untainted category, and this is very important. So 2 points I'll make straight away. First, I'm in the class 9 and class 10 band of assistant teachers. Second, I am not, in a manner of speaking, tainted either by the OMR issue or by the rank jumping issue. Nevertheless, the impugned judgment in para 363, Roman 2 says, all appointments granted in the selection process involved being violative of Articles 14 and 16 of the Constitution are declared null and void and cancelled. So one more fact I want to mention. At page G of my list of dates, I have given you the dates, so I'm not going into those specifics. I was appointed in 2018 and 2019. There are 3 petitioners. So between 2018 and 2019. I've been in harness for more than 5 years. Apart from being in harness for more than 5 years, Manoj, we've taught over there as assistant teachers in class 9 and 10. There's absolutely nothing against me. There's no finding. I'm not on any list of any CBI or anybody at all. Now, in this backdrop, let us go back to this paragraph 240 for a moment and just study it a little carefully. The 3 bands in para 240, which I understand is at PDF 252.
Yes.
Now, let's see these numbers. I'm on the first band of assistant teachers. 11,610. Now, I ask, the question I pose to myself is, could this have been done through an executive order? I believe if it were done through an executive order, this type of cancellation, that everything is going out, your lordship should have struck it down as treating unequals equally, which is completely wrong and has been frowned upon. Now, out of 11,610, the OMR issue, assuming there is an OMR issue, is only for 808. Now, look at the second column, rank jumping. I am not, as I mentioned, I am not on the
OMR issue is that the OMRs were not available.
There were some blanks, there were some available. But this is only what now, this is post, whatever the value of that investigation by the CBI.
On what basis did the SSC submit this statistical report? Now we are taking this report.
Because there were lists which were filed by CBI, for example, which were there. That list is also appended in annexures to this document.
Are those OMR sheets recovered from the residence of that Mr. Punk? That is the start and the end of the CBI's investigation. The CBI says that in some of those OMR sheets, some people who have got 0 have been selected. Now, that's the whole case of it. So, if that record which is recovered from the residence of that gentleman and that certificate has been attached.
How many OMR sheets have been recovered from Bansa's residence?
Mirror images. Number is there is no number given. There is no number given anywhere. If you will read the last of the CBI, the scanning was done, the board was to scan. Board of A to scan. Agency A gave it to agency B. This function is the employee of that agency. Then some employees of that agency split and make their own practice. And then Pankaj goes and joins those employees. And he has given a certificate as an employee of that split agency on the basis of record which is recovered from his house. And 25,000 people are losing their job. That is the whole open and shut case finished. The judge has addressed no other argument which was raised before him. And how did we lose our job? The single judge who was hearing the case, in one order says, this is a case where the board should exercise power under 17. 17 is a power with the board to withdraw recommendation. The board says, yes, we will look into it. We immediately file an appeal before the division bench. And we tell the division bench that we have been working for 4 years. Single bench in a 1-page order says, board to look into it and exercise power under 17. Division bench says, yes, you have no right to be heard. Finding number 1. Finding number 2, 17 will apply. The same day when the division bench passes the judgment,
The same day the board passes an order withdrawing our recommendation. And the next day our services are terminated. We come before this court here. Your lordship stays the termination. Your lordship stays the termination and says they should have been heard. And your lordship says, please go into the issue whether Rule 17 at all applies after a person is appointed and has served for 4 years. Now, all those arguments are raised. Not a single word on Rule 17. The petition challenging the vires of Rule 17 is separated, segregated, and not decided. And the whole judgment is based on this 65B certificate.
Mr. Patwalia, Bansal signed the certificate in what capacity?
My lord, as an ex-employee, just kindly see one paragraph. Just 1 minute. Just kindly see one paragraph in the judgment, para 305. The whole cat will be, just see para 305 to answer this question of my lords. Who was authorized, who did it, and who gave the certificate? This is a matter of lot.
Para 15. Yeah. Certificate is at certificate is at
Para 305.
Yes, just kindly see, Shyam, can I just show? Just kindly see para 305 of the this is the last report. CBI has filed several reports in these proceedings. In its report dated February 5, 2024, filed in compliance with the court order dated January 24, it has stated as follows. During investigation, it was revealed that the West Bengal School Service Commission, hereinafter referred to as the Commission, had awarded work order to Messrs. Nyasa Communication Private Limited, referred to as Messrs. Nyasa, for scanning and evaluating the OMR sheets pertaining to the selection of Group D, Group C, so and so. Investigation has established that Puneet Kumar was the then director and Niladri Das was the then vice president of Nyasa Communication during relevant period. It has been established during investigation that Shri Niladri Das was in charge of operations in respect of recruitment examination conducted by the West Bengal Service Selection Board, frequently visited the office to attend the actual operational part, did the requisite liaison on behalf of the agency for necessary compliance of instructions. Shri Puneet Kumar, being the director, mainly looked after financial affairs. Now what happened? Investigation has established that scanning of OMR sheets was undertaken by NYASA at the West Bengal Secondary Board Office at Acharya Sadan under direct supervision of Niladri Das in the presence of WBSCC officials. It has been further established that NYASA Private Limited had further given work order regarding scanning of sheets to Data Scan Tech Solutions Noida, who remained present at the premises for scanning. After completion of the scanning, the processed data in the form of scanned images of OMR, scanned data were handed over by Data Scan Tech to NYASA, who took the same to their officer located at Noida in digital form, leaving the hard copies in the office of the board. Board handed over their answer keys in respect of all subjects to NYASA. Now, none of these agencies is giving the certificate. I'll show who's giving the certificate. Your Lordship may now leave a few paragraphs and come to para 9. Because next paras they explain the files. Come to para 9. During investigation, the service database of the Commission was seized by the Central Bureau of Investigation, containing all data pertaining to selection test of group B, C, D, so and so. During investigation, 3 hard disks were recovered from the residence of Pankaj Bansal, an ex-employee of NYASA located at Ghaziabad. Who is this person, or how can this record be relied upon? It has gone changed 4 hands. Now it is in, they have picked it up from the residence. During investigation, these data files scanned, these 3 hard disks were recovered from the residence of Pankaj Bansal, an ex-employee at Ghaziabad. The certificate dated 16/9 of 65B from Pankaj Bansal was obtained. He has not certified on behalf of any of these 3 agencies. Now they'll explain who he has certified. Was explained in triplicate with regard to genuineness of the data concerned.
No, but what they say is the hash values of these data files of Scantech solutions were matched with the hash value of the corresponding files recovered from the hard disk seized from Pankaj Bansal and was found to be matching.
Correct. So Pankaj Bansal would probably get it. But I am nobody to say so. In the criminal trial, this matter is pending investigation. Today you take this as the gospel truth and throw out 25,000 people. Now, how this company is formed. Now, if your Lordship will see, your Lordship has just read para 11. Now, if your Lordship just kindly come to para 15, just come to 15. What has happened? That original company split, just let me read para 15. That it is emerged from the investigation that before leaving NYASA, Niladri Das and his staff
were identified in CBI.
Just let me read, sorry, para 14 onwards. It'll come, it is coming. Yes.
Of the CBI seems to indicate that the candidates in respect of whom there was a mismatch of the data have been identified. This mismatch establishes that the manipulation of marks of the written examination, the case of many candidates was resorted to and such candidates were identified. The comparison of these actual genuine OMR marks with the OMR marks available in the server shows that there is manipulation in 952 numbers of candidates for 910, 907 for 1112, 3481 for Group C candidates and 2823 for Group D candidates.
Apart from the fact that this segregation is possible, I am on a more fundamental point. My fundamental point is, how is this mismatch coming at all? The mismatch is because it is mismatching from what is recovered from Pankaj in his residence. Now, please read with me para 15. It's very important. 14 and 15 is very important. What happens to this data and where all has it gone? Just see now para 14. Para 14 and 15.
All right, read 13 also.
Yes, 13, no problem. That during investigation, several emails were found to have been exchanged between the accused officials of the commission, certain private persons, and officials of NASA. These emails contain lists of candidates whose OMR marks were found to be increased in the server of the commission. Besides, these emails have been exchanged between staff of NASA containing manipulated data of candidate. This shows complicity. This is all somebody's exit, Lord. But now let's see, read 14 and 15. During investigation, it emerged that in the year 2019, Shri Niladri Das of NASA Communication left NASA, started his own business in the name and style of Messrs. ND Info Systems. Now, this is the certificate coming. Now let's read further, Manoj.
CBI second deputy agent. I'm trying to call upon the other side. If anybody wants to argue for a minute so that you don't have the...
Just one more paragraph. One more paragraph.
This is very serious.
To argue, I need that.
Yes, yeah.
I'm going to argue for fundamental.
This is completely wrong.
How about Justice Gangopadhyay?
How are these people losing their jobs?
What a grave miscarriage of justice has taken place. It was he who ordered CBI inquiry. Pending that hearing, he gives a public interview and speaks loudly about this matter and says, I'm going to send everybody home. But this is shocking what has happened. Your Lordship will have to take cognizance of it. We cannot allow this kind of judicial misconduct to go unpunished. He gave an interview, and I will read interview, my Lord, in which says, yes, I have political aspirations. And someday if somebody invites me, I will accept it. But this is really, and not when he took cognizance, there was no prayer for CBI.
Mr. Dave, before we go into these broader issues, can we just focus on what the nitty-gritty of the matter?
Yeah, we'll go into the nitty-gritty.
We are 6 years, we have worked. Your Lordships are right. Please then grant a complete stay to us. Even this 956 people, what happened? This magical dish was sent to Forensic Science Laboratory, Hyderabad, by CBI. They said we cannot even verify it. They said we cannot verify. Now, as Mr. Patwalia rightly says, this is subject matter of criminal investigation. But pending that investigation, should we be damned? I can understand after a judgment. But in cross-examination, this Bansal will collapse in a minute. So, my Lord, we are being damned on this so-called, and my Lord, one thing, when your Lordships remanded the matter, your Lordship said...
Can we just for a moment have... 1 second. We want to hear again, Mr. Jaideep Gupta here. We just want to...
There is only one thing, Your Lordship.
Just call Jaideep.
Lord, when you are just a second, when your Lordships remanded... Abhishek, just a minute. Abhishek. When your Lordships remanded the matter, your Lordships expressly record, there is no evidence available on record as on today. Therefore, if there is any evidence, it may be put. Only evidence is this magical CD, which is completely inadmissible under section 65B2. It is not, the certificate is completely dehored 65B2 read with 65B4. Completely, read the certificate, my Lord. And your Lordship's judgment in 2014, which has said how this evidence can be taken. So, my Lord, we are being condemned after 6 years, my Lord. We have families. Nobody complained when Justice Gangopadhyay took the matter. There was not even an allegation of impropriety in that petition. I will show that petition. So, my Lord, it's something which is really a grave injustice.
I wanted to only intervene to alert one thing, Willis.
one thing. If you had a little bit of faith in the court, please sit down for 5 minutes. Let's talk to the other side.
All right.
We'll talk to the other side, hear them, and let's put our doubts.
Certainly, with one caveat for 1 minute.
If after hearing them, Dr. Singhvi, if after hearing them we are inclined to dismiss your petition, we will give you a full hearing.
I'm very grateful. I'm saying
something which you will expect from judges who are trained
question of not trusting the court. Well,
the technical aspect.
I want 15 seconds to point out something your lordship doesn't know. I am awaiting my turn because I am going to ask your lordships to unhear whatever you heard. I am a category who is nowhere in the CBI list, nowhere in the.
That's why we'll.
Unrelated.
If we are inclined to come to the conclusion.
Your lordship haven't heard our category.
If we are inclined to prima facie come to the conclusion that your petitions are to be dismissed, then obviously we can't throw your petitions out without hearing each one of them.
We are not started arguing.
Right? We just want to. We are conscious of the fact.
We'll wait.
Therefore, your clients also should not get the impression that we didn't hear you and then we are dismissing your petition. We have some doubts. Let's put them to the other side.
Certainly, but please keep in mind.
Jaideep, where is Jaideep?
Some of us are like this. You have not.
1 second now, please. Jaideep, is it possible? I mean, do we have any cogent material today to segregate the tainted from the untainted candidates?
That's right.
Yeah.
Now, you know that para 240, come forward. Para 240 of the judgment is a chart. Now, on what basis did you prepare the chart?
The digital data which they had obtained from that particular employee. And Millard, on that basis, it was prepared.
And we are out of that. That's the point.
And Millard, I may tell you one more thing, Millard. Based on that same CBI data, Millard, we have issued letters of revocation of appointment for some people. In fact, Millard, 2 of the issues raised but not decided because of the nature of the directions later on. 2 of the issues raised was whether we had the power to revoke under Millard section 17, rule 17, and whether we in fact correctly revoked or not. These 2 issues were raised. So, Millard, partly, Millard, we have already done the job of segregation, Millard. We had already removed some people. We had
all the 5 lists by them for 5 years. We are nowhere.
I am, Millard, only, Millard, saying that if your lordship permits the data to be looked into, Millard, we will be in a position to segregate. If, however, if your lordships feel that that data is not acceptable or, Millard, it doesn't have the necessary weight, Millard, then there will be a bigger difficulty.
Or a retired judge can segregate the chaff from the wheat.
No. First of all,
They're all influenced.
Highly.
They're all.
That's a different argument.
I'm sorry, Millard. First of all, we have to do
argument.
it. We have to do it. It is not something which can be done.
All right. Who's appearing for the other side?
I am concerned about my category. I'm out altogether.
Who's appearing for the other side?
This is a job which was sold in the market.
Some petitioners will not get it.
At all, that's going to be our point. So
That-
cannot ask to the will on the basis of a change which is non-existent. We need to show that to your lordships. This change is a creation, my lords, of one Mr. Pankaj, who is completely, my lords, incredible. His agenda was different. Ex-employee joining a competitor, and based on that, my lords, you create a taint. There's nothing to compare it to. There's nothing to compare it to. There's absolutely no evidence. And therefore, on that basis, a segregation is created because the commission wants to save some. That cannot be. They have to save all. There is no evidence.
Your lordships are dealing with category B employees appointed or recommended beyond the expiry of the.
Well, let's hear the other side.
Yes. On this, now, can I just take a minute?
We have come along. Let's at least hear the other side.
Very well.
Yes.
This is a job scam. Jobs were sold in the market at the price of 10 to 15 lakhs. And when
Now, how many people stand to be affected by this order cancelling what's the total universe
the
now?
total without cancel should be without 22,930. 25,000.
25,000.
Now, without
do we have precise figures?
Yes.
If you go to the synopsis at page B, we are considering 3 categories. Assistant teachers 9-10, assistant teachers 11-12, non-teaching staff group C, non-teaching staff group D. Now 4 categories.
Total.
Now, do we have a bifurcation among these 22,000 candidates? How many fall into each of these categories?
I just give you the detailed details.
Yes.
Will not the Joshua,
some idea.
In group D,
This chart is a total wide. 240 has all the recommendations.
Give us copy.
Extra copy.
Give us copy.
Recommendation was made 23,123.
This is yours. What you have given us.
Yes. Lord, this is on the basis of the data supplied by the school service commission, CBI.
Just please hand across a couple of copies.
And the illegal appointments total admitted till date was 8,000.
Now, 1 second. Just go step by step. Just 1 second. Give a copy, one copy to the other side.
SSC get.
All right. One, illegal appointments. Now, OMR issue, I mean, this OMR issue is a very vague statement. OMR issue is that the, how do you formulate the OMR issue?
That the WEMR sheets which were recovered by the CBI was given to the School Service Commission. They have accepted that. School Service Commission being the custodian of the WEMRs, they did not dispute the validity of the CBI retrieval, number one. Number two.
CBI retrieved these OMR sheets from where?
From the employee of NISA. NISA no more existed today. There are many situations which come for consideration. NISA had the Pankaj Bansal and Niladri. Now they have formed a new company. The CBI will raid it. They got it retrieved from Pankaj Bansal, who was the employee of NISA. And NISA no more exists today. That's very important. Now, when this retrieve supplied to the SSC, SSC says that we accept this, we do not dispute the validity of it. The furthermore important, during the hearing of the matter, the Honorable Court gave everybody opportunity to see the WEMR retrieved by the CBI. None has disputed that.
No, that is incorrect.
None of the candidate disputed that. That's a fact recorded.
Now the OMR sheets contained a manipulation, or what was the problem?
The WEMR sheets did not contain manipulation. WEMR sheets were filed without any marking, zero WEMR sheet. They have been shown to have secured more marks in the website of the SSC. That is the mismatch.
There is a discrepancy.
They have filed blank WEMR.
In certain cases, there is a discrepancy between the digital OMR data and what is the final record maintained by the SSC.
Yes. Therefore, the WEMR is the foundation which shows that there was a huge manipulation.
Yes, paragraph 69.
The number of mismatches are all started.
This is a great scam. That's why we say. And this.
According to you, in your chart that you have given us, the total number of recommendations which were made were 23,123.
My lord.
According to you, taking your case at its highest, the total number of illegal appointments admitted until date are 8,324.
Which could be found as of date, because the SSC files an affidavit before the court saying that we could not yet reach to the final calculation. That's the affidavit SSC work.
Right. But therefore, at the outset, I mean, the instinctive reaction is that if 8,324 appointments, according to you, are illegal, what is the ground for setting aside all 23 appointments?
No, my grounds are that entire selection process is tainted. Entire selection process.
How do you say that?
Starting from the appointment of NISA, the manner which was appointed, I will show the NISA people.
So assuming for a moment that NISA thing again from the shaft.
Yes,
Now,
I don't mind.
Right? So, then what is the justification for us today to uphold a direction for throwing out all 23,000 people en masse, unless we come to the conclusion, that the process is so tainted by fraud that the entirety of the selection has to go.
But that would be my submission if Lordship allows me to.
Now, point number 2, which we wanted to identify. One second. Mr. Gupta, do we have, is there today an identification of those persons whose appointments are one, illegal, in the sense of the OMR issue, rank jumping, beyond the number of recommendations after the expiry of the panel?
Absolutely.
But entirely on the basis of hard disks. The entire thing is on the basis of free hard disks which come from a source which is completely...
Hard disks are accepted by...
How can that be a basis? Because ultimately it leads to criminal consequences. No, but 65B is a very serious...
Look, if we have to, I'll tell you one thing. If we are inclined to take this, to reserve this matter for a fuller consideration. At the same time, we can't obviously, now it's obvious that some appointments are tainted. Right? We are not inclined, we may not be inclined, subject to hearing everybody, we may not be inclined to issue an unconditional order of stay in respect of all appointments.
Very well.
So those appointments which fall into certain clearly defined accepted categories, there can't be a stay in respect of those categories.
Very well.
Right? Now, which are those 4 categories which we'll have to exclude?
No, just one thing, look, working since 2018 and petitions filed 3 years later, 4 years later.
271 of the judge. 271 of the judge.
Millard, let me just summarize the position, Millard.
Just one second.
242, first 2 lines of paragraph 242.
Can you just give us the PDF page, please?
Just may I summarize? I'm not having anybody.
271.
Mr. Maninder, you are living in a bullock cart age.
Yeah, I asked my friend Millard, I didn't.
What? Your friend, you should have an iPad now.
Millard, may I summarize?
Para 242, if your lordships have it, Millard, first 2 lines. First 2 lines in para 242.
Otherwise, Maninder, go and take some training in the Delhi High Court. You'll get some good training online. This is not acceptable.
We will, Millard, with it. 242, first 2 lines. Para 242.
Mr. Dave, are you also in the same category or?
Millard, 242.
Just give me the PDF page. Anybody who has the PDF page, please tell us.
230.
All right, just look at those. Para
240 for the judgment.
You want to read 242?
It should be PDF 242. I'll come to 242, I'll read 273, then come to 265, just permit us.
Yes.
242. If your lordships have got it, Millard.
Yes.
In course of hearing, SCC did not discount the fact that possibilities of further illegalities exist. Now, before I go to 265, come to 273 straight away. 273. Because there are 3 authorities, all 3 have raised hands and candid that we cannot give you the total number. Please see 273. Yeah, 1 minute, bhaiya. SSC had 273. PDF 260. 273.
Yes.
SSC had no stage of hearing claimed that it was able to check all the records and be definite as to the number of illegalities in the recommendation made, but had limited itself to those figures as stated in the paragraphs above. In fact, reports in the form of affidavit filed by SCC from time to time had always stated that they discovered the illegalities as were brought to their notice by the litigants or an order of the court. This is number 2. Kindly now come to 265.
Before that, if not, she can take
now just 265. Para 265. 257 is the PDF page number. State government therefore has accepted there were widespread illegalities in the selection process. Now, these are admitted facts, nobody has disputed it. And that the number of persons who received appointment illegally
could not be determined with exactitude. So this is the foundation, my lord, in your lordship judgment that the entire thing has to go. They had resolved to create supernumerary posts to accommodate the illegal appointees. In other words, state has resolved to expend taxpayers' money to accord sanction to an employment secured dishonestly. Such course of action of the state violates section 14. Other two paragraphs, my lord, say that the SST says we have not made recommendation. Board says I have appointed on recommendation. Recommendation don't exist. And impossible to find out how many cases. And SCI admits candidly in its report, in every report, I have conducted this number and determined on the basis of the complaint received from the candidates and, my lord, the agency.
No.
I am reading only from the judgment.
There
is no ground that very well. Now, my lord, kindly see only 2-3 paragraphs more.
Para 33,
Kindly, my lord. Kindly come to 257. Para 257, role of the state government. PDF page 253. Para 257. And, my lord, your lordships were told no criminality has been found. A application for prosecution of the state officers is pending. When the High Court asked, by what time you will decide sanction, they said after the election. Kindly have a look, my lord, 257. The role of the state government in the writ petition and the appeals have been heard by us has to be taken into consideration. And your lordship may also keep one thing in mind. In addition to CBI, there was an SIT and the CBI to work with the SIT. SIT having sought sanction is in para 258. Complete evidence of illegality. And the argument on the other side which you were hearing, my lord, no illegality. Kindly see, my lord, as 257. Oh, kindly. I'm sorry. I'm so sorry.
Our question is very pertinent. Today we are trying to consider whether segregation is possible or not. Just come to internal page 240 of the judgment, which will be para 305
yes,
of the judgment.
Yeah, where this is
And
CBI report is quoted.
CBI report has been reproduced by undeserving candidates. That's your case. This mismatch establishes. Now the entire thing originated from residents of Bansal when those OMR sheets were recovered. And that is the reason why you have obtained 65B certificate also from him. Data is recovered
That
from
is CBI.
He has to say something, correct?
No, that would be CBI. I appear for a candidate, not a writ petition.
Fine. Just make us understand. Last 5 lines at 240. The comparison of
these actual genuine OMR marks.
So now there are 4, just 2 minutes. There are 4 categories. There is manipulation in 952 numbers of candidates of Roman 9-Roman 10. 907 numbers of candidates of Roman 11 Roman 12, 3481 numbers of grade C candidates, and 2823 numbers of grade D. Who are these candidates? Who are these candidates? What are the names of these candidates?
That the commission has to give it to your lordship.
No, we have the names.
No.
We have the names.
We have the names.
No, what I'm just.
The names and the roll numbers of the candidates.
The more important question is not who is Pankaj Bansal. He never had custody of this. They've taken hard drives from an ex-employee who CBI itself says that he was not the person in custody. Niladri Rai was.
On the hash values, the hash value has to be
Anything here is. One sec.
That in the same report, earlier paras of the same report shows that Niladri Rai was from NISA who was in charge of this. Pankaj Bansal was never there. And an ex-employee who is illegally holding on to some hard drives, those hard drives procured by him, they take a 65B certificate from him.
Then
The accused person, an accused person who is never in custody.
If with regard, Lord, if with regard to every candidate, there are two OMR. One with the lower number and one with the increased number. That's the end of the matter, my Lord.
Only on the basis of an illegally hard drive.
The only thing is that can that be said about every one of those?
That's what I am respectfully submitting, my Lord. That the commission says I have not examined the entire record. Whatever examined, this is the result. Let them examine fully.
SSC come
Number one.
The statement before they go to an affidavit who are genuinely done. We have no concern with that.
The number two, my Lord, the state is castigated here. Kindly have a look at the state, my Lord, what the High Court has found.
If the SSC says they are genuine, they're genuine.
If, my Lord, the OMR is for every candidate, there are two OMR, the entire case be done afresh.
ওই যে অ্যাফিডেভিটটা বার করতে হলো বার করতে পারবে না ওর লাস্ট অ্যাফিডেভিট আমরা করতে পারছি না ফাইনালি যেটা আমি দেখি যেটা রেকর্ড করেছি
Lordship, my lord,
One
only, if my learned friend, my lord, if your lordships can come to page 243,
Yes, my lord.
PDF. I don't have the papers, my lord. But I'm not given the papers.
Before that, my lord, your lordship is just keeping in mind, my lord, various cases have come up with regard to this kind of a illegality. And the illegality modus operandi which seems too common is, my lord, that the original OMR within the commission, blank OMRs, my lord, where the candidates' numbers are changed are always either in the chairman's house or somebody who's close to chairman's house. They are all caught for, or collected from there. But the point which is, my lord, what deserves your lordship's consideration is that if, my lord, in the table at page PDF 243, if the illegality is from 10% to 45% in the OMR, with the statement of the commission, state as well as the board, that the entire record has not been examined without examination of record, if the OMR inconsistency is between 10% to 45%, in 4 exam, my lord, it's a classic case of calling for a fresh election. And number 2, yes, 1 second now.
Pilot will.
But who is the statement to make a decision on my behalf?
Now that the OMR seats to be destroyed.
The FCI was
They want to argue.
1 second.
my lord, the argument of 4 years and 5 years has been raised. My lord, in the judgment of Honorable the Chief Justice, my lord, in that FCI case of 2017, that where, my lord, caste certificates were false. And, my lord, Constitution bench believed that given a benefit to a postgraduate medical student, which fell for your lordship consideration, that is, my lord, reported as 2000.
The CBI investigation, the CD goes.
In fact, my दे दो ना यार.
Not the CBI report.
हाँ आगे बढ़ के दे दो. That's it. Give it to them.
Kindly appreciate that.
Money को count.
But this is not
Master साहब, what master?
All right, wait, 1 second. Just 1 second. Look, if we look, unless we orders have maintained some order, we'll never get.
Not we didn't even speak a word when they were arguing.
All right, what we'll do is we'll place this in July. We'll place this in July. We'll just issue notice and place this in July. That's it. There'll be no stay of anything. Either we are staying.
Can I say one job? Can I say job?
We find that it's impossible to.
Give us 5 minutes each.
It's impossible to have an orderly hearing.
Yes.
We will just simply issue notice. This is in July.
Not. We didn't open our mouth when they were arguing.
In the morning, we have had very ordered arguments. Now we find that there's only a slanging match going on.
Correct.
We'll simply issue notice, place it in July. No stay of the investigation, no stay of the judgment of the High Court. That's the only way we can.
Lord, kindly don't do that, Lord.
Otherwise,
Give us 5 minutes for the petitioner.
Lord,
we did not open our mouth when they were arguing. And they
were not.
This thing, please don't say this.
However, 1 second, please. However sensitive the matter is, however politically fraught the matter is, we must understand that we are lawyers here.
Correct.
If we want to be politicians, we can go to parliament, we can go to the state legislature.
We are not
in the court, we are lawyers.
We are.
We may be on either side of the ideological divide. We don't care as judges about your ideological issues. We are concerned with the legality of the issue.
That's the point.
Right? If so long as everybody just bears that in mind, just leveling allegations against High Court judges, that's not going to carry the penny any further because we have to decide on the basis
Till that time, your Lordship called upon us, we didn't open our mouth. Lord, your Lordship called upon us, follow this judgment, 3 judgments I am handing over, Lord, starting from Krishna Yadav. Krishna Yadav is the first.
Please regulate us. Please regulate us for 2 minutes each. Please regulate us for 2 minutes each.
With this kind of unruly behavior, all that we can do is not a matter to be dismissed. We'll issue notice. We'll issue notice.
We are not
listed after
we are not doing it. Lord, if I can complete in 2 minutes, please have a look at those judgment.
We will
call out names for 2 minutes.
The reason why we said yesterday that we will have an order for counsel to appear is that one counsel will argue at a time.
Yes.
We told you that if we are inclined to dismiss the petitions, we will hear you fully.
Yes.
We are not inclined to dismiss the petitions. Therefore, we wanted to hear them.
My turn is not even.
I will not take by the clock more than 2 minutes. Just 2 minutes. Where is the Lordship will be shocked?
1 minute only. Your turn is over.
Let's understand what they have.
2 minutes, fellas, by the clock.
1 minute, Lord, only.
My turn is not even, Mr. Maninder Singh. Others will also have
1 minute. 1 minute.
No. You should, at some point of time, you should stop.
One person who is not a writ petitioner.
Yes,
he was not even completed. Failed.
You don't know. I don't know whether my learned friend is aware for whom he is appearing. I am appearing for the writ petitioner.
2 minutes.
He may be having many clients. I have only one.
One sec.
Lord, may I just say something?
Only one client.
Lord, may I
take one suggestion?
2 minutes. 2 minutes.
May I just say something? But in fact, I couldn't open my mouth to have the petitioner. Argue the matter in court below.
It's 2 minutes by the clock.
Yes. We are rising for 10 minutes. We'll come back at 10 past 4 and we'll dictate a short order over here.
Kindly hear us.
Only one.
Our turn has not come.
Issues notice.
Our turn has not
There
come.
would not be.
We were waiting for our turn.
Complete. My lord, that's the difficulty.
Sorry?
My lord, issuance of notice, my lord, would ensure that service is not complete. It would never be heard. My lord, therefore, that's my concern. My lord, as a lawyer, my lord, I am saying.
Because there will be too many parties to serve.
We were waiting for our turn. We were waiting for our turn. We are waiting.
Those who are waiting for the turn may be heard.
A lot of point which has not been made till now.
Your Lordship can order publication, but not that. This is not a
Forget
make service.
Well, I am saying 2 minutes. Give 2 minutes.
We'll direct publication because there's no question of individual service. And most important, we have sufficient representation of all different, a variety of interests here. Normally, in a matter like this, if people are unrepresented, there's an issue.
Yes.
We have adequate representation on both sides, including of a varied interest. So it's not an issue.
So allow 2
My
minutes.
category, I have not even been able to open
By
my
the
mouth.
clock. By the clock.
Give us 5
We have not argued. We're waiting in our queue.
All right, 1 second.
2 minutes
We'll
by
come
the
back in
clock.
exactly 10 minutes now. Tell us who remains to be.
I will not argue at all. I'll take 2 minutes.
I represent.
I'll take 2 minutes.
After vacation.
After vacation,
After vacation.
Please clock it at 2 minutes.
What should be here is tomorrow. 5 minutes is all that it.
We'll take it up. We'll continue.
There's too much at stake.
Just 2 minutes.
The interim order already passed, maybe extended.
Tomorrow. We'll take it up tomorrow morning.
But my London has given an order.
So we have already come. We have heard Mr. Pratik Dhar. We were following that order. Now the next Mr. Rodgi was not well, so Mr. Madiyal has argued. Mr. Sham Diwan has been
started.
Yes, Mr. Sham Diwan is on his legs. We are going to have follow with Mr. Patwalia, Dr. Murlidhar, K. Parmeshwar, Mr. Dushan Dave, Mr. Giri, Dr. Singhvi, then
In item 27 and
then Mr. Amit Sharma, Siu Singh. Now, look, if everybody has to argue, we'll not even be able to finish.
Give us
Just 5 minutes. 5 minutes, that's all.
There's no point in.
5 minutes.
Please fix it at 5 minutes. Please fix it at 5 minutes.
By the clock,
I would not
5
repeat
minutes.
any point. Just 2 minutes on a fresh point which has not been addressed.
In 2 minutes, I'll stop.
Limit
Just.
it to 2 to 5 minutes, whatever your lordship says.
For the purpose of deciding whether to dismiss the matter or whether to entertain the matter, we have heard enough. We have heard for a whole day. What we are proposing to do is
We are on interim relief.
we are rising for 10 minutes. We'll come back and we'll dictate a small order after 10 minutes.
Just give us 1 minute.
I'll take your leave, my lord.
You still have your.
No, not.
This batch of specially petitions under Article 136 of the Constitution arises from a final judgment and order dated 22 April 2024 of a division bench of the High Court at Calcutta. In 2016, the School Service Commission in West Bengal conducted selections for the recruitment to 4 categories of posts. Bracket 1, assistant teachers for classes 9 and 10. Bracket 2, assistant teachers for classes 11 and 12. Bracket 3, non-teaching staff of the Group C category. And bracket D, non-teaching staff of the Group D category. A notification for the state level selection test was issued on 16 February 2016. Full stop. An OMR based written examination was held on 27 November 2016. Full stop. The final panel for candidates for class 9 and 10 was published on 12 March 2018. Let's stop. The merit list and panel candidates was published on 28 August 2018. Let's stop. The candidates joined as assistant teachers in or about January and February 2019. A batch of petitions was instituted before the High Court challenging the selection process of 2016. Full stop. The selection process for assistant teachers was governed by the West Bengal School Service Commission, bracket selection for appointment to the post of teachers for classes 9 and 10 in secondary and higher secondary schools rules 2006. 16. Full stop. Likewise, there are rules governing the selection to assistant teachers for classes 11 and 12, also of 2016. The selection for the Group C and Group D non-teaching posts is governed by the West Bengal School Service Commission, bracket selection of persons for the appointment to non-teaching staff, bracket rules 2009. Page E and F को मिल जाएगा. The writ petitions before the High Court were instituted in 2021. Good stop. From time to time, orders were passed by the High Court annulling the appointments on the ground that the process, on the ground that the appointments were made illegally. Let's stop. The appointments were assailed initially before the division bench of the High Court, and ultimately dispute traveled to this court. By its judgment dated 9 November 2013, sorry, 9 December, yeah, sorry, I said 13. 9 December 2023, 9 November 2023, this court, while dealing with a batch of petitions, directed in Achinta Kumar Mandal and others versus Lakshmi Tunga and others, footnote deke, SLP civil number 4078-4079 of 2023, that all the issues relating to the appointments of 2016 should be examined by a division bench of the High Court. And accordingly, an order of remand was passed, was issued. Accordingly, an order of remand was passed. This is the order of remand has resulted in the impugned judgment of the High Court. Let's stop. The High Court has held, inter alia, that bracket 1, all appointments made in the selection processes involved were violative of Articles 14 and 16 of the Constitution, and therefore null and void. As a consequence, of the judgment of the High Court, approximately 25,000 appointments. We have the exact figure.
25,735. 25,735.
All.
All right. Approximately 25,000 appointments would stand to be abrogated, 25,000 appointments would stand to be set aside. Let's stop. During the course of the cases before the High Court, There was a direction to the Central Bureau of Investigation to conduct an investigation in regard to the alleged illegalities, in regard to the alleged acts of criminal wrongdoing arising from the selection process. When the matter traveled to this court, the order, the order dated 9th November 2023 directed the CBI to complete its investigation within 2 months and to submit a report to the High Court. In the meantime, this court directed that the appointments which were granted during the pendency, that the appointments which had been made shall stand protected for a period of 6 months to enable the division bench to adjudicate upon the matter. Next. In the earlier order dated 9th November 2023, this court was of the view that the direction of the High Court for the termination of the services of candidates at the interim stage, even before the final disposal of the petitions, ought to have been avoided full stop. Before the High Court, as indeed before this court in the earlier proceedings, a fundamental issue which arose for consideration was in regard to the admissibility of the OMR sheet images which had been recovered by the CBI full stop. The court noted that the investigation by the CBI was yet to be completed full stop. The admissibility of the OMR sheet images being in question this court observed that the question of the exercise of power in relation to the discovery of electronically stored OMR sheets implicated serious allegations in regard to the manipulation of records, having regard to the number of persons who are likely to be affected by the outcome of the proceedings, it was considered appropriate to remand the proceedings back to the High Court for a final decision on the writ petitions. Before dwelling further on the ultimate directions which have been issued by the High Court, it would be necessary to note at this stage that and it would be necessary at this stage to make a brief reference to the report dated 5 February 2024, which was the last report, which was the final report which was filed before the High Court. The report of the CBI notes that the West Bengal School Service Commission, into brackets WB-SSC, just write SSC, had awarded a work order to a company by the name of NISA, NYSA Communication Private Limited, for scanning and evaluation of the OMR sheets pertaining to the selection tests for each of the 4 categories The scanning of OMR sheets was undertaken by the aforesaid company at the office of the SSC. It further emerged during the investigation that the company which was awarded the contract by the SSC had further assigned the work of scanning the original OMRs to an entity by the name of Data Cantech, SCANTECH, Solutions Noida, which was present at the SSC for completing the scanning work. According to the CBI, after completing the scanning, the processed data in the form of scanned images of the OMR were handed over by Data Scantech Solutions to NISA Communications Private Limited. In the digital form, leaving the original hard copies of the OMR sheets in the office of the SSC. Full stop. The according to the CBI report, the SSC handed over the answer keys for all subjects to NISA Communications Private Limited for evaluation of the OMR responses. CBI seized the server database of the SSC during the course of the investigation. Full stop. On 15/16 September 2022, 3 hard disks were recovered from the residence of a person by the name of Pankaj Bansal, a former employee of NISA Communications Private Limited at Ghaziabad. Full stop. Certificates dated 16 September 2022 under Section 65B of the Evidence Act were obtained from Pankaj Bansal. It says 16th actually. The report says 16th. 19th, all right, 19th. During the course of the investigation, data files containing scanned OMRs, among other things, were seized from Data Scantech Solutions. The report of the CBI notes that a comparison of the actual the report of the CBI contains the following observations in paragraphs 12 and 13. ये आप कॉपी कर लीजिए पेज 279 and 280 PDF में मेन मैटर में. The above investigation by the CBI indicates that a comparison of the indicates that it has found a manipulation in respect of 952 candidates for the selection process of teachers for classes 9 and 10, semicolon, in the case of 907 candidates for classes 11 and 12, semicolon, 3481 candidates for group C and 2823 candidates for group D. Full stop. That apart, comma, the report of the High Court notes that chart is para 240, na? Yeah, 240. Can you give me one page? Apart from the above report of the CBI. The impugned judgment of the High Court contains in paragraph 240 a reference to the fact that the SSE had submitted a statistical report of the 4 selection processes tabulating the alleged irregularities. Full stop. The tabulation is reproduced below for convenience of reference. ये आपको PDF page 243 को मिल जाएगा.
Paragraph 271 also.
Yeah, I got it.
271.
Yeah. I have it. I've made a note. I was coming to it in a second. 259 now. The High Court has also noted that in response to its queries, the SSC had submitted details of the recommendations which were made by it in respect of the 4 categories and the number of appointments issued by the board. Full stop. In the case of classes 9 and 10, in the case of the selection process, don't say that, just say this. The figures submitted by the SSE indicated that the actual number of persons who are appointed by the board was in excess of the recommendations made by the SSC to the following extent, bracket 1, assistant teachers for classes 9 and 10 -1539, उसके नीचे 2, assistant teachers for classes 11 and 12 -199, group D posts -669, and 4 group C posts 416. Let's stop. On the basis of the data which was submitted before it by the SSC, the High Court has noted, the High Court has observed, into brackets paragraph 241, that the illegalities admitted by the SSC cannot be said to be within tolerable margins in a selection process of a large magnitude, and that the SSC did not discount the fact that the possibilities of the existence of further illegalities may still exist. The High Court further noted into brackets para 273 that the SSC had not been in a position to state that it had checked all the records so as to be definitive about the number of illegalities The state government had also accepted that there were widespread illegalities in the selection process. Full stop. The next, on 19 May 2022, the state government the government of West Bengal, in the school education department, issued an order in exercise of the power, in exercise of the provision, in exercise of the power conferred by Section 19. Don't say in exercise. Creating 6861 supernumerary posts of teachers and non-teaching staff for absorbing waitlisted candidates and directed that appointment letters to such waitlisted candidates should be issued in terms of the recommendation of the SSC, subject to the outcome of the pending litigation before the High Court. The court has been apprised during the course of the hearing that a petition under Article 226 of the Constitution WP capital A 250-256/2022 has been instituted before the High Court to challenge the order of the government creating the supernumerary posts to accommodate the waitlisted candidates and the full stop by an interim order, the government order creating the supernumerary posts has been stayed. That petition is still pending, right? Pending. It is common ground that the petition is pending before the High Court. In this backdrop, the High Court, by its impugned order, has, while setting aside the appointments, directed that bracket 1, the OMR sheets available in the 3 hard disks must be uploaded on the website of the SSC to persons who had been appointed from outside the panel, after the expiry of the panel, and against the submission of blank OMR sheets, must return all the remuneration and benefits received by them to the state exchequer, together with interest at 12% per annum, failing which recoveries, the outstandings would be recovered as arrears of land revenue. Semicolon, bracket 2. The CBI shall interrogate all persons who had received appointments beyond the panel, after expiry of the panel and after submitting blank OMR sheets, if necessary, by undertaking custodial interrogation, semicolon, bracket 3, CBI shall undertake a further investigation with regard to the persons involved in the state government who had approved the creation of supernumerary posts to accommodate illegal appointments, if necessary, by conducting a custodial interrogation. Semicolon, bracket 4, the SSC shall undertake a fresh selection process as a consequence of the vacancies which are declared on the setting aside of the appointments. Full stop. Other consequential directions have been issued. Next. The primary question which has been urged in the course of the hearing by the learned counsel appearing on behalf of the petitioners fall under four broad heads. Bracket 1. The data on the basis of which the High Court has set aside the appointments of nearly 25,000 persons, including assistant teachers and those appointed to non-teaching Group C and Group D posts, is itself suspect. Since the foundation of the entire exercise is the certificate under Section 65B issued by Pankaj Bansal, a former employee of NISA Communications Private Limited, from whose possession the 3 hard disks were seized. 2, in a selection process having such a large magnitude, cancellation of the entirety of the select list should be a matter of last recourse. And whereas segregation of the tainted candidates is possible, only such appointments should be directed to be discontinued. 3, the above consideration must apply a fortiori in a situation where the petitions were filed nearly 3 years after the appointments were made, and the direction, particularly because the direction to set aside the entirety of the appointments would have serious repercussions to employees who have served the state and 4, while there can be no 4, where the appointments which are tainted are capable of being identified, comma, should be manifestly unjust for the High Court to set aside the entire selection process. Stop. On the other hand, comma, it has been urged on behalf of the respondents who have supported the judgment of the High Court that both the SSC and the state government were not in a position to specifically identify to state that the possibility of further illegalities can be ruled out. Stop. In this backdrop, when a systemic fraud has vitiated the entire process, comma, the High Court was justified in setting aside the entirety of the selection process. Next. We are of the view that the submissions which have been raised on behalf of the petitioners would merit further consideration. But stop. The issue pertaining to, don't say the issue pertaining to, the certificate under Section 65B of the Evidence Act was issued, comma, as the CBI report notes, comma, by Pankaj Bansal, who was a former employee of NISA Communications Private Limited. But stop. The legitimacy of the certificate, which has been obtained from the above individual, would prima facie lie at the root of the data which forms the basis of the judgment of the High Court to set aside the entirety of the appointments. That apart, comma, from the material which has been placed on the record before the High Court by the SSC and by the CBI during the course of its investigation, it would emerge that the appointments which suffer from taint from what did I say? From the material? Question from the course of the investigation, comma. A further issue which would merit closer analysis is as to whether the appointments which suffer from a taint can be specifically segregated. Full stop. If such an exercise is possible, it would be unfair to set aside the entirety of the selection, which extends to as many as to approximately 25,000 appointments. Full stop. The court cannot also be unmindful of the impact of the setting aside of a large complement of assistant teachers who have been recruited for both class 9 and 10 and class 11-class 12 students, which would be the consequence if the impugned judgment were to be upheld as it stands. Full stop. Assuming that such a segregation is possible, this court would have to determine the modalities which would be followed for that purpose. Full stop. At this stage, the court must be guided by the fact that by its order dated 9 November 2023, this court had protected the appointments which had been granted subject to the direction to the High Court to expeditiously dispose of the writ petition. Full stop. Bearing in mind the High Court, bearing in mind the present stage of the matter, we are of the view that an expeditious and early disposal of these proceedings would be in the interest of justice, and we accordingly direct that the proceedings be listed for hearing and final disposal on 16 July 2024. Stop. In the meantime, we are inclined to continue the ad interim protection which was granted by this court in its order dated 9 November 2023, subject to the express stipulation that persons following in the that any person who is found to have been appointed illegally and is continued as a consequence of the present order shall undertake to refund the entire amount of the salary which may be paid between the date of this order and the final judgment of this court. Full stop. This would cover illustratively the 4 categories of individuals noted earlier, namely bracket 1. We need not we can just say for the 4. In paragraph 240 of the judgment, which has been reproduced.
Your Lordship have not said anything about the state sub.
Now we just on the earlier date, the High Court has, by its impugned order, directed the CBI to investigate the creation of supernumerary posts at all ranks of the state government. Full stop. The above direction of the High Court was stayed by this court.
You didn't stay that, only said no precipitory action taken.
The above, this court, by its previous order, had directed that no precipitate action would be taken in
Clause 8 may be stayed.
In pursuance of the direction contained in clause 8 of the operative directions of the High Court, which is reproduced below. Just give it the PDF page, please, of that.
We'll give it to the court master. 281, my lord, possibly.
Para 363. Para 363. Clause 8.
Mr. Rakesh Dwivedi and Mr. Jaideep Gupta, when Mr. Rakesh Dwivedi appearing on behalf of the State of West Bengal
and Mr. Neeraj Kaul.
And with Mr. Neeraj Kishan Kaul, Learned Senior Counsel, state that as a matter of fact, no appointment whatsoever has been made in pursuance of the order of the state government dated
19th May 22.
May 2022, which in any event forms the subject matter of a pending writ petition before the High Court, where the creation of the supernumerary posts has been stayed. Good stop.
Except one, Lord, that was.
That was
A cancer patient.
That is an exception.
Which even this
However-
division bench has upheld.
However, it appears that there is one exception has been made in the case of an individual
That is not
on
a
medical grounds.
post.
Soma Das.
That is not a supernumerary post, right? All right.
It's a supernumerary
that's
post.
all right.
Soma Das.
That's all right. Nobody is setting aside her appointment, right? Don't say that. The earlier order of this court, in regard to the above direction of the High Court, shall continue to remain in operation.
I'm great.
Pending the subject to the aforementioned subject
We are giving an undertaking.
to the above subject to the above stipulations, comma, the judgment of the High Court dated so and so shall remain stayed till
Judgment also directs us to further investigate. Directs CBI to further investigate.
That has
we have
been
not,
stayed.
we have the investigation in regard to the creation of supernumerary posts.
No, my lord, your lordship staying the order would stay the CBI investigation as well.
That's only in regard to the supernumerary post.
Kindly see, Lord, 7 is only a minute. Lord, I have not said anything, but let me say it. Lord, kindly see 7.
Look, we will not stay clause 7.
I'm not concerned with 7.
All right. The direction, we however clarify that the direction contained in operative, that the following direction which has been issued by the High Court in operative direction 7.
And 9, my lord. 9 is to file report.
7 again, there's no appointees to take custodial interrogation.
No, 7 we will not stay because 7 covers 4 cases who had received appointments beyond the panel.
Yes.
After the expiry of the panel, submitting blank OMRs to.
I'm sorry, Milord. I'm sorry. Sorry, Milord. On that, our custodial interrogation.
Lord, there has to be, my lord.
We, however, permit the CBI to continue its investigation in respect of bracket 1, persons who had received appointments beyond the panel, semicolon, bracket 2.
Dispute. I'm sorry, Milord.
Persons who were appointed
I have stay of this.
That's seriously in dispute, Milord. We have challenged.
We should go those who have been identified.
Milord, let 16th of July, Milord, the judgment as such will be stayed. Sorry.
No, investigate.
The judgment.
All right, Aisaliko, in modification of the previous order, we direct that the investigation, which has been ordered by the High Court, pursuant to clauses 7 and 8 of its operative directions, in paragraph 363, by the CBI shall continue, but no coercive steps shall be taken.
Not 8.
Not 8, my lords.
Why?
My lords, 8 involves the cabinet.
That is supernumerary, my lords.
8 involves supernumerary, the cabinet force. And that's why your lordship stated. Your lordship says 7 and 9, not 8, my lords. That is people who prepared the cabinet.
They identified illegalities. No,
Second.
7 and 9.
We have said 7. 9 is an adjunct of 7.
Yes.
8 in regard to the creation of supernumerary reports we have stayed right now. So
The lordship may just clarify that. That's all that we are saying.
Just one second. The supernumerary posts, we have recorded the statement of the government that not a single appointment has been made to a supernumerary post. And that's the subject matter of a pending petition before the Calcutta High Court where that has been stayed.
The court was asking.
And insofar as the other categories are concerned, in clause 7 of the order, we are permitting the CBI investigation to continue, subject to the stipulation regarding clause.
It's a grant.
Grateful, my lord.